Senate will come back to order. First up, messages from the House, and I'm not referencing my forehead. Let's go ahead.
From the House of Representatives, March 9, 2021, message number 189. Mr. President, the following bill passed the House on third reading by the vote indicated. House Bill number 104, Uniform Trust Code Amendments, ayes 60. Message number 191. March 9, 2021. Mr. President, the following bill failed to pass the House third reading by the vote indicated. House Bill number 133, Online Sports Wagering, ayes 28, noes 32. Message number 185, March 9, 2021. Mr. President, the following bills passed the House in an amended form. House Bill number 33, Interference with Public Contracting, ayes 60. Message number 186, March 9, 2021. House Bill number 73, Birth Certificates, Gestational Agreements, ayes 43, noes 17. Message number 187, House Bill number 101, Elk Fee Ground Closings Requirements, ayes 58, noes 2. Message number 188, House Bill number 102, Wyoming Preference Act of 1971 Amendments, ayes 58, noes 2. Message number 190, House Bill number 121, State-Funded Capital Construction, ayes 41, noes 19. Signed, Wendy Harding, House Chief Clerk.
Mr. Majority Floor Leader.
Mr. President, I move the Senate resolve itself into the committee of the whole to consider only the budget bill at Senate File 0001. What? We're not all here. How long do you know? You got it handled? Who's going to present the budget?
Well, there may be some explanations. Let's do this. Let's get it done. And Senator Steinmetz will handle all questions. All right, you've heard the motion. All in favor, say aye. Those say nay. Motion is passed. Senator Land to take us back into the budget. Senator Steinmetz will back you up.
Good afternoon, everybody, and welcome to the second half of our doubleheader this afternoon. It's beautiful outside. Okay, I think Senator Steinmetz, I think your colleagues, at least one of them I saw came back, and are we good to get started where we need to start? Senator Steinmetz, catch me up on who's got this next particular section.
Thank you, Mr. Chairman. It's actually Senator Perkins, but I guess I'll pinch hit for him.
Yeah. We kind of like that, as a matter of fact. Senator Steinmetz, I think you're talking about, I believe we left off section 85, the Wyoming Business Council. Is that correct?
Actually, Mr.
Or I think we finished the Board of Patrol.
I thought we finished the Board of Patrol, so let me get back to where we were at. Are we on the Business Council? Then I would defer to my good Senator Guru for the explanation of the Business Council, Mr.
Okay,
Chairman.
thank you, Senator Steinmetz. Senator Guru, did we leave off at section 85? I believe we did. And Wyoming Business Council, Senator Guru.
Yes, thank you, Mr. Chairman. Page 27 of your summary sheet, and I do not have the bill on the number on the bill. Someone to help me out. But as you can see here on the Business Council, the governor made some changes. A total cut of $4,064,000, and then let's see, I'm gonna run down here. See footnote number 1, JC adopted the governor's total reduction on 100 series personnel services. In the 200 series. Oh, here we go. Number 4, JC reduced we reduced $1.25 million of the general fund in the 600 series for grant and aid payments in the Business Ready Communities program, and added footnote number 2 to biennialize the reduction. So that was the change that was made by your Joint Appropriations Committee. And I see that the good chairman is also here, so one or the other of us could probably answer any questions on Department 85, the Wyoming Business Council.
Okay, thank you. For section 85, senators, any questions on the Wyoming Business Council? Questions on section 85? Seeing no questions, section 85 is closed. The next section for our consideration is section 90, the Wyoming Energy Authority. Senator Perkins.
Thank you, Mr. Chairman. The only thing that happened on the Wyoming Energy Authority is as we talked about before, we zeroed out the Wyoming Pipeline Authority. We zeroed out the Wyoming Infrastructure Authority pursuant to action we took a year ago, and we created the Wyoming Energy Authority. And so it just consolidates those two budgets in the Wyoming Energy Authority. Other than that, the only thing I have to say is there's a couple of very modest reductions regarding the closure of the Wyoming Pipeline Authority in Casper. And so there's some money that's going to come back from there. And also there's a vacant administrative position, a third-party accounting contract, and eliminations of a couple of other things, some duplication that would have been extended through the offices. And again, this is not new money or new positions. This is a combination and a consolidation. And actually, in some respects, there are some economies of scale, and those are being realized, and that's what constitutes the budget reductions in the Wyoming Energy Authority.
Questions on section 90, the Wyoming Energy Authority? Seeing no questions, section 90, the Wyoming Energy Authority is closed. Next section for our consideration, section 96, the State Budget Department, a brand new department. Section 96. Senator Perkins.
Thank you. Senator Hicks is excused, so we'll try and cover the vice president's back, Mr. Chairman. The State Budget Department, again, what this is, remember, if we had that one bill that came through here, the budget division was pulled out of A&I and made into a separate department. No new money, no new positions. What you do have there is you just got a couple of very modest reductions regarding some printing of budget books. There's some modest reductions regarding that. There is also to reduce some 200 series support services for them. Also some modest reduction to their 900 contract services for enhancement. And regarding hosting the state budgeting system, IBAR, somehow I guess they were able to find some efficiencies there and deal with. And so that's what we've got there. There's also, and there's a 300 section series that talks about carryover funds that we'll talk to when we get to that. But that's all that really happened in the State Budget Department. Thank you, Mr. Chairman.
Questions on section 96, the State Budget Department? Seeing no questions, section 96, the State Budget Department is closed. The next section for our consideration is section 98, Office of Guardian Ad Litem. Senator Steinmetz.
Thank you, Mr. Chairman. Page 29 of the summary sheet and page 71 of the budget bill is the Office of the Guardian Ad Litem. It was reduced by $383,071 for a total general fund reduction of 8.79%. The Office of the Guardian Ad Litem, or GAL, and since I'm the only gal on the Appropriations Committee, how fitting that I present the Guardian Ad Litem, was removed from the Office of the Public Defender in 2020. The JAC adopted all the governor's recommendations. Thank you, Mr. Chairman.
Questions on section 98, the Office of the Guardian Ad Litem? Section 98 is closed. Office of Guardian Ad Litem. The next section for our consideration is section 101, the Supreme Court. Senator Perkins.
Thank you, Mr. Chairman. Section 101 of the Supreme Court, you find on page 72 of the budget bill and page 29 of the summary review. The major things that we did, before I get to that, I guess I'll back up and just say the court system provides a unique challenge to trim back. A significant part of the salaries that you find are set by statute. And so unless you change the statute, we have to pay what's in statute to be paid. Additionally, there's also constitutional issues about reducing the pay of judges sitting during their term. So there's a number of issues that come into play there. And at the end of the day, and we'll get this as we go into particularly into the court system here in just a minute, Mr. Chairman. For the most part, it's people. We have people who work there, and other than some, we've got some IT support that we'll talk about. But you've got some people, you've got judges assistants, and a little bit of administrative work, and that's what you've got. So anyway, but they still went after it with a gusto when they found some things to delay and some things to cut. So I think the major ones I'd like to bring to your attention that are significant, as you see that they did under note 1 in the summary review, they adopted the total recommendation, which was the court's recommendation. These are not governor's recommendations, but the court, the Chief Justice's recommendations. They reduced $470,000, some change, which was particularly a full-time equivalent position, and some serious support services and some contract services to reduce that. We also adopted the court's recommendation to include also a reduction of some additional full-time positions. You can see up there, there's a reduction of five full-time positions and 3 part-time positions over the entire court process. I think that the other places that were significant cuts, I think if you look at, we did a couple of things. Also in note number 2, the JAC had dropped the court's option A to delay the Chancery Court implementation for another biennium for an additional savings of $320,000 to put that off a little bit. And what's talking that there is the court still intends to operate, but we did in the initial legislation allow until a judge was appointed to serve in that capacity, allowed some retired judges, retired Supreme Court judges, or sitting district court judges who had the time and the inclination to participate to do that. And so the object is that will still move forward, but we'll do it with existing judges or otherwise make other recommendations. And so we're able to save a little bit of money there. I also refer you to note 5 and the summary where we also reduced about almost right at $340,000 for some support services related to the municipal court case management system. And also the court gave us some other options about delaying some expenditures. And so we're delaying, I think, for another year, the appellate case management system that needed to be replaced. We're going to delay that a year, and that's a one-time savings of $1.7 million and some change. And then we amended the footnote 3 to help conform with that. And also would bring to your attention note 6, where we also delayed a recommendation, took a reduction of about a $250,000 and reduced some part-time judges who passed away and do not have surviving spouses, and so that affects some of the payout that happens there. Those were the main issues that we had to the Supreme Court, and they contributed what they could to the overall budget situation. Thank you, Mr. Chairman. Would stand for questions.
Thank you, Senator Perkins. Section 101, the Supreme Court. Any questions for Section 101, the Supreme Court? Section 101 is closed. The next section for our consideration is Section 103. Judicial Conduct and Ethics, Section 103. Senator Guru.
Thanks again, Mr. Chairman. Section 103 is found on page 30 of your summary sheet or page 74 of the bill. It's not a big department, but they have a $37,000, a little over 10% cut in their budget. And if you look down on footnote number 1, this is taken out of the 900 contract series, and it was for expert witnesses. And I'd be glad to stand for any questions.
Any questions on Section 103? Senator Perkins, did you want to add to the discussion on this one? Thank you. Section 103, Commission on Judicial Conduct and Ethics is closed. The next section for our consideration is Section 120, Judicial District 1A. Senator Perkins, do you have a motion to make?
I don't know that I have a motion, but we're not just going to talk about 120. We're going to talk about 120 through 140, excuse me, keep going. We're going to go all the way to section 143, which is on page 37. So we're doing pages 20.
I guess it wasn't going to be a motion, but I suspected that you had an idea for us.
But we're just going to do all these at once because they're just, these are all the district courts. And so every district court judge is its own agency. And we're just, so this is, we're going from pages 30 all the way to, as I said, section 141 on that we're doing. So we're putting all those pages to put on the summary review in your budget bill. This is going to go from beginning on page 75 all the way to page 86 in your budget bill. So these are the district court judges. Like I said, some district courts have one judge, some district courts have up to, I think, 4 judges here in Laramie County. And every judge is its own agency, and there's a few exceptions, but every district court is pretty much structured the same way. You have the judge, you have an administrative assistant, you have a law clerk, you have a reporter, and in some cases there might be another half a person, or in some case maybe even one person. And that's what every district court is, and that's what they do. And we send those 4 people forward to dispense justice across our state. Other than their personnel, they've got a little bit of copying in their budgets, and they've got a little bit of travel in their budgets. And a couple, and a few other modest expenses to pay that. So what you find as you go through and we deal with this is every one of those you'll see about these same things. They went in and made some modest cuts, mostly to in-state travel. Sometimes there's a little bit here for some copying and some things like that. And those all went through. About the only exception to that, I would point out on page 31, what's not there. And I think we have section 124 and section 125 are not in the budget. And so those are 2 judicial districts. I think if I remember right, 124 is the judge in Pinedale and 125 is the judge in Sheridan. And the reason that they're not in there and don't have those cuts is because those two judges travel a lot. The judge in Pinedale travels down to Fremont County to the courthouse in Lander a lot, and also travels up to Jackson quite a bit. And there's a lot of, and just do that on a very regular basis. The judge in Sheridan spends a lot of time down in Buffalo. And so the budgets for those 2 individuals were cut. And so you don't see them in here. But as you go through, you'll see that that's what the essential cut was. And then the only exception to that was that there was one, I'm not sure about this, and maybe it's because this judge never leaves the office, but there's a judge in Cheyenne that we cut $10,000 out of their budget. So I'm not exactly sure why that was, and I don't exactly remember, but I think that is our newest district court judge here in Cheyenne. But that's what we did with those judicial districts. And with that, I would stand for questions. Thank you, Mr. Chairman.
Senator Perkins, just for clarification, I believe that did take us through section 143 Judicial District 1D. Is that correct? And to the Senate, any questions about the district courts? Section 122 through 143. Senator Nethercott.
Thank you, Mr. Chairman. I'll be brief here, but I have to take a moment. You heard the testimony from the chairman of the appropriations about the number of district court judges in our state that have to travel and travel extensively. As you can understand how challenging that can be for the administration of justice. So I look forward to your continued support in understanding how we can make our courts more accessible through technology. Certainly the pandemic has helped, but I think that is a useful tool to help us cut back some of these expenses and understand how we can bring access to the people of Wyoming to our courtrooms. So thank you, Mr. Chairman.
Any other questions or thoughts on the district courts? Senator Perkins, any final comments?
No, Mr. Chairman, we'll just, if it's okay with you, we'll go to section 151.
Okay, thank you, Senator Perkins. 120, before we do that, Senator, I've got to close some sections. So section 120, section 121, section 122, section 123, section 126, section 127, section 128, section 129, section 130, section 131, section 132, section 133, section 134, section 135, section 136, section 137, section 138, section 139, section 140, section 142, and section 143 are closed. The next section for our consideration, and I'm catching up to myself, Mr. Chairman. The next section for our consideration, I believe, is section 151, the district attorney, judicial district number 1. Senator Perkins.
Thank you, Mr. Chairman. We have two district attorneys in the state. One is in Judicial District 1, which is here in Cheyenne. The other one is in Judicial District number 7, which is in Natrona County or the Casper area north of here. In both of those, they submitted their budgets. The governor had, and the JAC adopted the governor's total recommendation of reduction of about $140,000 in personnel staff, and also went through this stuff where we were going to furlough some of these folks a little bit, backed off of that, and I think we're just down to a 1-day reduction, a furlough reduction, and a one-time full-time equivalent reduction. And those are, again, most of the expenses in these are personnel, and so those cuts were made by the district attorney in Laramie County. That's what happened. They'll stand for questions.
Thank you, Senator Perkins. Any questions on section 151 and section 157?
I didn't do 157 yet, Mr. Chair.
Okay, Senator Perkins, you want to do 157? I bet it sounds a lot like 151.
It does sound a lot like 151. Both of them had a little bit different way to deal with how they were going to deal with the cuts that the governor wanted. In Judicial District 7, again, you see a very close amount of additional reduction in services, reduction of some full-time equivalent positions, and so what they made those reductions, and they also adopted a supplemental recommendation. Didn't include one full-time practicing attorney, so they traded off some staff and some other people to do that, but did pick up one additional attorney. Unfortunately, crime continues to be a growing business in our state. Stand for questions.
Slightly different presentations on both senators. So section 151, any questions on section 151? Section 151 is closed. Questions on section 157? 157, District Attorney, Judicial District number 7. Seeing none, section 157 is closed. The next section for our consideration is section 160, County and Prosecuting Attorneys. Senator Perkins.
Thank you, Mr. Chairman. The county and prosecuting attorneys, every other county in the state other than Laramie County and Natrona County have county and prosecuting attorneys. Because district attorneys only prosecute crime, Laramie County and Natrona County have separate county attorneys, which are not funded through the state, but funded solely by the county. Everywhere else in the county, your county attorneys are elected, and they double not only as the county attorney, but the prosecuting attorney. And so in these models, and the way that we've funded county and prosecuting attorneys throughout the state are that there's kind of a cost share between counties and the state. The county's supposed to reflect or carry the burden of the civil side of what counties do, and then the state is supposed to be paying for most of the, if not all of the criminal side of what they do when they put on their hat as a prosecuting attorney. The JAC adopted the governor's recommendation of a $633,000 reduction for 800 series non-operating expenditures. And those are simply what that is. Those are simply amounts that are distributed out, much like state aid would to a community college or a block grant to the University of Wyoming. It's a reduction of state aid out to the counties and to reduce the money that they have available to do their jobs in your respective counties. And would stand for questions on section 160, Mr. Chairman.
Thank you, Senator Perkins. Section 160, county and prosecuting attorneys. Any questions? Questions on section 160? Section 160 is closed. The next section for our consideration, section 205, education, school finance. Senator Kinski.
Thank you, Mr. Chairman. Ladies and gentlemen, I'll be covering two sections back to back, 205 school finance and 206 Department of Education. And there's a little bit of interplay between them, but school finance is the piggy bank where the money is that fuels the school system, at least from the school foundation program. And that's funding for the schools directly. And then there's some other sorts of categories besides the school foundation program by which money is dispensed out to the districts. The 205 itself has only 3 employees, although you'll see there's quite a bit of money there, just shy of $2 billion. So the first bit of action we had in this budget, you'll see on page 38, the supplemental, and we're on page 88 of the budget. You'll see in bright red the figure $884,183. Well, what this was is in Unit 206, the Department of Education, what they recommended is to take $884,000 worth of general fund expense and swap it for $884,000 worth of school foundation program money. And it was the feeling of the JAC that didn't actually achieve any savings. It was just moving the problem from the left pocket to the right pocket. So that recommendation was denied. So we can ignore that footnote 3 on page 38, where we denied the governor's rec of this $884,000 swap out. And so that $884,000 expense remains in the Department of Education, drawing upon general funds. However, there was a feeling, principally an amendment moved by one of our colleagues on the other side of JAC, who's quite an ardent education advocate, but he felt that there were some areas where some savings could be made from the school foundation program. So what he did is he fashioned 3 reductions, and each of those reductions was not by a specific line item, but he just said to each of these units, let's take this much cut and then leave it to the administrator to figure out exactly where that difference is going to come from. And that would be footnotes 1, 2, and 3. So you'll see on page 38, as well as on page 88, we call out some specific elements of this section 205. The school foundation program, court-ordered placements, something called foundation specials, another unit called education reform, and another unit called student performance data. So what JAC adopted in footnote 1 was to go into foundation specials. And that is a $4.3 million budget. And the move was to cut $657,000 out of school foundation expense out of this unit. And it's up to the administration to figure out whether it's going to come out of the National Certified Teacher Program, out of CTE grant program, or out of distance education grant program. It's not that this unit was overfunded by any means, or any of these units, but it was felt based on the best information we had available to us that they could take a 15% haircut and still do quite well. So that is the first cut. That's footnote 1. Footnote 2 was the second cut. And this was to remove $1,162,396 from the education reform unit out of a $7.7 million budget. And this largely consists of contracts for student assessments. And again, it'll be left to the department as to exactly where to accommodate that reduction to the school foundation program expense. And finally, on footnote 4 of your supplement, there was a reduction to the unit called student performance data of $957,000 against a $6.3 million budget. And this primarily consists of what's called the WISER registration, which is this, it's a universal ID for students where their names are scrubbed, but they track their performance data, and it's ultimately supposed to enhance accountability as students move through the system. And it was felt there again that of that 6.3 million, they could spare the 957, leaving it to the administration to figure out exactly where, rather than telling them exactly where it would come from. So those 3 in aggregate amounted to a 15% cut, a reduced spending out of the school foundation program. And I thought I had somewhere here, the aggregate is $1.9 million. With that, I'll stand for questions on school finance, section 205.
Section 205, education, school finance. Any questions, senators? Anything on section 205? Section 205, education, school finance is closed. The next section for our consideration, section 206, the Department of Education. Senator Kinsky.
Thank you, Mr. Chairman. Now I'm on page 39 of the supplement and page 92 of the budget. So we're going to move through these footnotes in the supplement in several sort of broad swaths. The first series of footnotes would be the governor's cuts. And so if you would circle footnote 1, 4, 7, and 10. These were cuts that the governor recommended to the Board of Education, to the unit leadership and finance, to the unit accountability and communication, and to the unit school support. And we accepted all of those. There is one that I want is of note. I think it's worth taking a look at, which is on footnote 2. This is a reduction of $44,305 as part of the Board of Education, but they only have one employee, which is an at-will contract. And so essentially that is being reduced, but a footnote was added to say, by the way, we want you to keep that employee for the Board of Education. They need to have at least one staffer supporting them. And then another footnote that sustained the reduction into the next biennium. So those were the governor's recommendations, which we accepted. The next series of footnotes would be cuts by JAC of approximately 15%, aggregating $930,000 in all of school foundation program money out of the Department of Education. That would be footnotes 2, a reduction to the Board of Education, footnote 8, a cut to the accountability and communication, and footnote 11, a cut to school supports. And the footnote 8 is a 15% cut, or $761 to $31 million budget. Footnote 11 is a cut of $125,000 to a $384 million budget, 95% of which is federal funds. But it was felt that we needed to at least begin the process of winding some of these things down. And you know, every dollar you put back into the school foundation program out of these programs it's available there for the classrooms and the classroom teachers. And again, this was just a cut to the unit. We didn't tell them which line item to take it out of. We left that up to them. The next footnote is footnote 12, which is the Talking Books program, or the people that wrote, it was the Books for the Blind program. And that was a cut of $70,000. And for all the difficult cuts that we've made in this budget, for some reason, this one was spared from the Woodsman's Axe. And the Books for the Blind money was put back, and that's what footnote 12 is. That cut recommended by the governor was restored. Then let's dispose of several other footnotes. Footnote 3, footnote 5, footnote 6, 8, and 9. These are these were motions by one of our colleagues to take school foundation program money and move that expense over onto the general fund, which makes the school deficit look less awful, but it makes the general fund look worse. And those of us on your Senate Appropriations Committee didn't really see much sense in just moving it from one pocket to the other, so we opposed it. We lost that on a 7-5 vote. But when we get to the second reading, our Appropriations Committee Chairman will bring you a motion to say, let's just reverse those things back the way they were. It's not really helping the situation. It just makes one budget look worse at the expense of another. So that disposes of all of the footnotes on page 39, and I will stand for questions.
Thank you, Senator Kinski. Senator Scott.
Mr. Chairman, my question is, do you have a total sum if we adopt all the real reductions to the foundation program expenditures that JAC made in these budgets? What is the total savings to the foundation program?
Other questions on section 206, the Department of Education, before we go back to the descriptor of the section? Any other questions? I'm going to kill a little bit of time here as the senator gets some help at the back so that he can answer Senator Scott's questions. Chairman Perkins.
Thank you, Mr. Chairman. It just occurs to me that here that we're almost done with this, I might go back and give a couple of remarks regarding some people that this is their first time looking at this document. So if you just pick any page you want and you go across the top, and sometimes those have been a while, forget because this stuff becomes second nature.
Senator Perkins, you're looking at the
I'm looking at
supplement
the
or
summary sheet.
the summary sheet.
And so if you look at, just pick any page and you look across the top, when you see GF, if you haven't figured out yet, that's general fund. FF is federal funds. OF generally means other funds. And then when you see a code, you'll see that there's a number of things you'll find, like S5 is generally the school foundation program. Now, all of the codes you'll find on the first page 2 and page 3 of the budget bill, you'll find all the codes so you can figure out what they are. So, because I mean, there's like, and then you see another thing you'll see quite often is an SR. An SR is just a special revenue fund. Generally, special revenue funds are agencies may be charging fees or other things. And so there's an internal service or an internal generation of some money. And so those SRs are generally special service funds. And so if you see an application or you see out there in code and we're talking about special revenue funds, those are funds that come from another source, usually fees or other, somebody receive, another thing that's fairly common is in the Department of Education, they may put on a seminar and then you have to pay to attend the seminar. And then they use those fees to offset the cost of putting on the seminar. And now those fees, as they do that, would be considered special revenue funds as an example. So as you go through and see that, the TT is tobacco funds. And so you'll see that. But again, as you go through and look at that, And this all starts to make, and it only takes about 10 years to get this kind of sort of, so you kind of have a handle on it. But again, the first pages 2 and 3 of the budget will give you what all those separate funds are. And some of them you'll see in here and some of you won't. When we get to the budget next year, you'll probably see most of those at some point show up in the budget bill. But I just thought I'd point that out. It occurred to me as we're sitting here that when we talk about, look at so much of this stuff is, if this is your first time here, it's still Greek. And don't worry, there's only one language you don't speak here, and it's all Greek to us. So anyway, appreciate it.
Senator Perkins, thanks for that. And just to add to a little bit of clarification, Senator Perkins, would you be willing to walk us through what the rest of the week's going to look like? So today, we will finish this first view of the budget. And by 5 o'clock this evening, that is the deadline for budgets to be drafted that will be considered beginning tomorrow. Is that correct, Senator Perkins?
Yeah, so tomorrow we will do the second reading of the budget. The second reading of the budget, obviously a second reading, we hear amendments. And so all of the amendments that are second reading amendments, we will hear those. We'll debate each one. The same rules apply in second reading. I think the same rules apply in second reading as far as time limits. And when we discuss those, we'll go through those. You have your 2 shots. Everybody gets their 2 shots at 5 minutes. Please don't feel obligated to take all of your 5 minutes or even 2 shots at 5 minutes. But some of them are obviously more important and take more discussion than others. I think, but we'll do that. But again, 5 o'clock today is the deadline for amendments on second reading. So we'll go those and bring you have to, I made a mistake last week, Mr. Chairman. I wore tennis shoes and it turns out I was wearing comfortable shoes on Friday. It turned out they were too comfortable. Apparently, at least for the men, I think for the women too, you're supposed to wear shoes that can be polished. They don't have to be polished, but they're supposed to be able to be polished. So I can't wear my canvas sneakers, but wear comfortable shoes and comfortable clothes, although you have to comply with the dress code because sometimes this goes on. We've been out of here at 9, 10, 11 o'clock at night to get to it. It takes however long it takes to get through second reading. And so typically, and I don't, back when you had other leadership, we'd bring in pizza or things like that because you do get owly and growly, hangry as we go through, and we'll do that. But that's what tomorrow is. Then Thursday we'll take off. We won't do budget Thursday. It'll just be a regular day. But your amendments to for third reading have to be in by 5 o'clock on Thursday. And then we'll come out Friday, and whatever amendments are not out on Friday, we'll do whatever. And again, Friday's just like that. We go until we're done. And maybe it's a good thing because I think there's a snowstorm maybe to dump up to 10 to 12 inches this weekend. So maybe none of us are going anywhere on Friday. So maybe it's just as well. So, but we'll do that. Same type of thing. We go until we're done. I would remind you that as you prepare amendments, particularly for those who are new to this, if you have what's called a mirror amendment, so you have someone down the other end of this building has an amendment that is the same or substantially similar as yours, mirror amendments are a done deal. If they both pass, unless they're undone, a second reading amendment is undone on third reading or something like that. Mirror amendments are done. And when the conference committees of the House and Senate get together to reconcile that bill, the mirror amendments are essentially untouchable. So I just would bring that to your attention if you haven't been through this process before. And so that's the process we'll work through. It's a busy week. In the meanwhile, we always want to keep the pipeline moving. So we always do every day. We want to do second reading, third reading, committee of the whole, regardless of where the budget is. So we have work we have to continue to do, and the budget kind of takes center stage, but we have to do the other work as well. And so we just judge we take however long it takes to get her done. Thank you, Mr. Chairman.
Chairman Perkins, thank you. So that among the takeaways are no Chuck Taylors, and the jury's still out on this leadership team regarding pizza.
That's right.
Okay, so.
It'll be done before you need.
All right. So Senator Kinsky, thanks. I know you've been working diligently there at the back to come up with an answer or two. So Take it away, Senator
Well,
Kinski.
Mr. Chairman, I'm embarrassed that I was ready for a much more difficult question from my friend from Bates Creek than just after the smoke clears, what in aggregate, what was saved. And let me get back to you on second reading, because by the time we get through the netting out process, and I just need some time with staff, I'll get you that number. I was ready for something much more difficult. Were there other questions though on 206?
I'm
Mr.
getting
Chairman?
ready to ask for that, Senator Kinski. This is section 206, the Department of Education. Want to make sure there are no more questions. No more questions on section 206. So section 206, the Department of Education, is closed. The next section for our consideration is section 211, the Board of Equalization. Senator Guru.
Thank you, Mr. Chairman. Section 211, Board of Equalization, page 40 of your summary sheet, page 94 on your budget. See a reduction of $294,313. And if you look here, this is direct your attention to the one footnote. JAC recommends the governor's reduction. How is that achieved? Downstairs, they got a little creative down here. What they did was they appointed the general counsel to the Board of Equalization, thereby freeing up some money for lawyers' fees, because they would like them to act as their own counsel. So that was how that was achieved. So they'll hire out some counsel fees, but actually end up saving quite a bit. So they were quite creative downstairs on that one, and be glad to answer any questions.
Section 211, Board of Equalization. Any questions, senators? Any questions on 211? Section 211, the Board of Equalization is closed. The next section for our consideration, section 220, the Environmental Quality Council. Senator Perkins.
Thank you. Again, we're going in for the vice president until he gets back. So the Environmental Quality Council, there was just the only action there was we just adopted the governor's recommendation of $109,000. And that just includes a little bit of reduction in serious personnel services, support services, and some contract services to, small department with a small budget. And so just some cuts there. As you've seen, nobody escaped the knife in this deal. So thank you, Mr. Chairman. I'll stand for questions on the Environmental Quality Council.
Questions on section 220, the Environmental Quality Council. Section 220, Environmental Quality Council is closed. The next section for our consideration, we get into the section 300s. And Senator Perkins, how would you like to handle the 300s?
Mr. Chairman, if it's okay with you, what I would do, and you can either read the footnotes there, or, it's just as well, if you want to take a look at these footnotes and what we're doing, you can go to beginning on page 96 of the budget bill. And with your permission, I'll just walk through these sections. If you want, I'll stop at the end of each, like section 300 before we go to section 303, and we'll just do that. But I'll just run through and give an explanation of all the section 300s, whatever your pleasure is, Mr. Chairman.
So Chairman Perkins, I think we can maybe walk through the 300s, and I'll be happy, senators, to come back. But I think these section 300s, let's just go through them, if you don't mind, Senator Perkins.
Sure.
We'll come all the way back and go through them if we have questions. Thank you.
Thank you, Mr. Chairman. Section 300, and just so you know, ultimately what the footnotes are all about is one of two things. Either one, there are the governor has evolved in his thinking about footnotes. He used to think they were horrible things. Now he finds that they have some use. But ultimately, what it is, they either put some restrictions on the appropriation and uses of appropriation, or they manifest an intent with respect to a portion or a part of all or part of an appropriation. And so the footnotes are really how you can tell if there's a difference from the governor's recommendation, or if there's specific intent with respect to that. Sometimes those footnotes are in because the governor wants them. Sometimes they're in there because the legislature wants to seek and make sure that certain things are accomplished within the footnotes. We've always had an interesting relationship with footnotes. Sometimes we've tried to be a little bit more restrained than last year. Sometimes you'll find entire bills put into this budget bill through a footnote, or we're trying to be a little bit restrained on that. But with that, I'll just launch into what we're doing here. When in the section 300 specifically, which is on page 96, we're doing a couple different things. The JAC denied the governor's recommendation for a transfer of $7 million from the school foundation account to the SIPA to assist with funding K through 12 school major maintenance, which some of that comes directly out of the SIPA account. This recommendation was based on an October 2020 Craig that showed the school foundation account with a positive balance. However, as we move forward to the January 2020 Craig, it was revised down a little bit. And so section E, or subsection E of section 300 authorizes the transfer of 19.6 million from the SIPA account back to the SCA, the school construction account. This transfer was made to zero out the school construction account, which was revised down due to the January 20 K and actually showed that we were basically overdrafted in that account. And so this transfer would bring that back up and get it to zero. Section H, or subsection H of section 300 authorizes the transfer of $10.5 million from the Excellence in Higher Education Reserve account to the trust funds corpus. If you remember, that's one of those permanent accounts that we provide support for chairs and some other events in teaching and excellence in our community colleges and our university this year. And so the reserve account is pretty full. This account experienced an 18% realized returns in fiscal year 2020. And so this is just taking in some of the money out of the reserve account. We believe there's enough in there to accomplish the reserve account and making sure that it goes into the corpus and will continue to earn interest and dividends and earnings going forward. For the following items, the governor made recommended reductions to items that were appropriated in other 2020 bills. And so this section ensures that we can accept those reductions and just tries to make sure that when our two ends of the bridge meet, that we've actually got a bridge in the middle that goes all the way. So we have subsection J of section 300. We adopted the governor's recommendation in the Department of Corrections to reduce $150,000 from another bill, which is intended to establish a quality control unit and address mental health and substance abuse disorder services for inmates. And this was from last year's House Bill 31. When the governor made, this is just a straight up reduction. And when the governor makes this reduction, there's still $174,380 left in that account. Subsection K of section 300 adopted the governor's recommendation in the governor's office of the Wyoming coal marketing program. Last year, we appropriated $1 million for that program in House Bill 2024. This is a $50,000. This denotes a reduction we made in the governor's office earlier in the bill. When this is done, there'll still be $950,000 in that account for a coal marketing program. In section 300, subsection M of section 300, the JAC adopted and included the governor's recommendation in the governor's office for the animal indemnity program. This was from House Bill 99 last year, and this would zero out the account. There was $50,000 put in here for various indemnities with respect to animals that had to do with brucellosis and either indemnifying ranchers that either had to quarantine their herds and for those expenses, or if some of their herd had to be destroyed, it would indemnify for those expenses. So section 300 subsection M would zero that account out, and that money would no longer be available for that purpose. Subsection N of section 300 adopted the governor's recommendation in the governor's office for the trust land proposal study. This had to do with House Bill 162 from last year. What we did is, if you remember, we appropriated $150,000 for one of those school sections in Teton County to go out and do a study about uses and how we could maybe monetize the value of that. The Office of State Lands, we're able to do that internally. That study is done. It's been reported back, and they did not use any of that amount. And so this is returning all of that money back. It was not used and didn't need to be used. With
Senator
that,
Perkins?
that's section 300, Mr. Chairman.
Thank you very much, Senator Perkins. That's exactly what I was going to point out. That is 300. Senators, any questions on section 300? Any questions? Senator Schuler.
Thank you, Mr. Chairman, and I'm on the right bill and the right year this time. Just a question on footnote 320. Wondered about I knew that they had recommended the Wyoming Works program going away. I wondered about those students that are currently in that program and maybe how that affects them. If you could elaborate a little bit. Thank you.
Senator Perkins.
Mr. Chairman, when we get to section 320, we'll certainly do that. I think our next section is section 303.
That is correct. And Senator Perkins, maybe we could delineate a little bit. I know that some of our senators will be working off of the summary sheet and many following you in the bill. Are there any 300s that you wanted to emphasize out of the summary sheet? And that may be where the senator was going. Is that, I'll give you a second to look down through there.
Well, and we're going to cover those. I'm actually going through each section individually and each subsection individually in ascending order. And and so we're going to cover every note. All the ones we just did were in section 300. We'll next go to, if you see the footnote on page 41 of 303, and we're just about ready to talk about 303 as the next section. So we will
Okay.
cover all those footnotes in due course, Mr. Chairman.
Perfect. Chairman Perkins, thank you. And so seeing no questions on section 300, section 300 is closed. The next section for our consideration is section 303. Senator Perkins.
Thank you. Section 303, this simply authorizes the state budget department, which went from was a division and now is a department. It just authorized them to carry over funds in their budget system for the IBARs. And this is approximately $42,000. IBARs is the electronic and the IT system that we use to develop the budget throughout state government. That's all that section 303 does.
Questions on section 303? Seeing no questions, section 303 is closed. The next section for our consideration, section 308, Senator Perkins.
Thank you, Mr. Chairman. Section 308 is this fund swap. This is one of those things where there's simply not enough money in the general fund to cover all the checks that we looks like we're gonna have to write this biennium. And so this helps solve some of that problem. So what this does is adopts the governor's recommendation with regard to major maintenance. And this is not it does not impact school major maintenance. It does impact major maintenance on state buildings, community college major maintenance, and University of Wyoming major maintenance, but it does not involve, this particular note doesn't involve major maintenance to school, to the K through 12 schools. So what we did is we adopted the governor's recommendation on a major maintenance. We moved the major maintenance multiplier from 2% to 1.5%, which is a 25% one-time reduction. This is not biennialized. It's a one-time reduction for this biennium. That's what the note does. It's just this shift, like I said, just affects state buildings, community college major maintenance, and University of Wyoming major maintenance.
Questions on section 308? Any questions? Section 308 is closed. Section 311, Senator Perkins.
And section 311, this just includes concurrence with the governor's budget recommendations as requested and applied to the budget bill unless specified differently within the bill, which means that if you find a brand new footnote in the bill, that's probably something that the legislature did and comments weighs in further. But there's just a few of those. I think we touched on most of those. We went through the bill, but this just ultimately states that unless we've got a new footnote, we're generally concurring with these footnotes, and they're mostly just to implement and provide intent for the expectation of the governor's recommendations. That's all that section does.
Questions on section 311, senators? Any questions for the chairman on 311? Section 311 is closed. And the next section for our consideration is section 314. And Senator Perkins, I did want to point out that in the summary sheet, we do identify section 304 employee benefits, but it does not appear in the bill. So Let's keep that in the back of our minds. I don't know that we need to deal with
Well,
it.
and I can speak to that, Mr. Chairman.
Okay.
What you had is in the original budget bill, we had some money that was going to go into the contingency fund for the employee group insurance. And so ultimately, that's not needed. As I said about that, that account is now healthy. I think there's over $60 million in that account, which is about where it ought to be. And so that footnote is, or excuse me, that section just simply clarifies that what we did earlier is not going to happen. We're not going to put any more money in there.
My sense is that we don't need to close section 304. Let's move on to section 314. Senator Perkins.
Thank you. This was a place where your Joint Appropriations Committee differed from the House Committee, and this was a 7-5 vote on the adoption of 314. What this did is, as you can see, the cross out, this eliminated 2 transfers from the 1% severance tax account to the LSRA and the Permanent Minimum Trust Fund once on April 21st of 2021, and then once after the end of the biennium. The effect of removing this footnote is it will freeze the 1% severance tax account, and it will just remain in the 1% severance tax account. Will not go to savings. It will be available for other spending. I think you'll see in one of the amendments we have tomorrow is to undo that and allow that to flow into savings. And we'll have some more information about that tomorrow, Mr. Chairman. But that, as the bill is structured, that simply holds that, and it would delay and prohibit any of those transfers.
Sounds like more coming tomorrow on section 314, but any questions today on section 314? Section 314 is closed. The next section for our consideration is section 320. Senator Perkins.
Thank you, Mr. Chairman. Section 320 adopted the governor's total reduction recommendation to cut new funding out for the Wyoming Works program. There was originally in the bill $1.5 million for the Wyoming Works student grants in section 320D of the original budget bill, and another $1 million of the general fund for the Wyoming Works program in section 320E of the bill. Both those, this doesn't cut the old funding, but it cuts the new funding for that program. The original funding was in the bills that were passed when we created those programs. This one eliminates new funding that was extended to those programs last year.
Questions on section 320? Seeing no questions, section 320 is closed. The next section for our consideration, section 339. Senator Perkins.
Thank you, Mr. Chairman. The Casper Office Building Advisory Task Force, which is mostly made up of legislators in Casper. And so that original task force sunset in 2020. This comes back out and reauthorizes the advisory task force to continue on and finish its work. That building's coming along and will be finished this year, I do believe. And it does appropriate $10 million to non-legislative members who are on that to travel and to participate in that program. Legislators who participate out do not receive pay or per diem for their participation on that program in that task force. What's that?
Questions on section 339? Senator Anderson.
Mr. Chairman, did he say 10 million? I'm on that board. I got to get to work on this.
You know, that's a few zeros among friends, Mr. Chairman. 10,000. I'm sorry.
Good thing you clarified that, Senator Perkins. I allowed that Senator Anderson to jump in there before you could clarify.
It's nice to know that Senator Anderson was not asleep and paying attention.
Section 339, any questions, senators? Section 339 is closed. And the next section for our consideration is section 399.
And
Senator
last but
Perkins.
not least, Mr. Chairman, these are 3 repealers. What they do is a section 327 repealer. What that is, and this also goes back to, I think, 304. The section 327 in the budget bill last year appropriated $21,330,000 from the LSRA to the Employees Group Insurance, or EGI, for shortfall employer contributions. This was as a last resort fund in case of other emergencies or other backup, and all their appropriations or pools in that fund are exhausted. The fund was not needed because, as we talked about earlier, the CGI or Employee Group Insurance Reserve accounts recovered in the last year. And so we don't need to do that anymore. And that repeals that section.
Questions on 399, Senators, section
We
399.
got two more repealers there, Mr.
Oh,
Chairman.
I'm sorry. Excuse me, Senator
And then
Perkins.
the next thing, the other section that's repealed in there is 329, which required the governor to make approximately $2 million. We instructed the governor to make $2 million in personnel services reduction in his department. His total one series reductions and reduction recommendations in the budget are over $38 million that the governor has cut out of his offices. And so we think that we just recognize the good work, and he's already meet and significantly exceeded that goal for him. So we're just removing that requirement from the budget. And also the other thing, the last section that's repealed is section 330, which appropriated $250,000 of the general fund for mass layoff support. However, as the COVID fund came through, we didn't need that. One thing we haven't talked about that we learned in the last little week, your appropriations committee, is as we looked at major layoffs and the COVID response that was done, there was the balance kind of when COVID started of the UI fund was about 300 and some million dollars, I think. In 2020, the UI, the Unemployment Insurance Fund, distributed over $467 million of UI benefits in that fund. That's $500 million, just sneaking up on $500 million was distributed out of that fund in UI benefits to Wyoming residents who either lost their jobs or have their hours reduced because of COVID related and during the pandemic. And so out of that number, we between not included in the 1.25 billion that came in for COVID relief, there were additional monies that came out through the COVID coronavirus, the CARES Act, that specifically reversed that. It paid just right at about $350 million of that was paid for by distributions from the federal government for the very purpose of supporting and UI benefits, unemployment benefits for people. So there has been a drop of about 90-some million in that fund. Part of the bill we did last year also said that when we did this, those charges would not meet, if they're COVID related, would not go against employers' experience ratings. And so that means that for the most part, although we found a few exceptions, that employers were not charged directly for in their experience rating. But what that does mean that employers there will be a fund charge that comes back in UI to start rebuilding that as it goes forward. Would also tell you that the governor and the legislature also put in about 25 million to bolster that fund back in September, which actually, when you run it through the actuarial programs, we got about a 2-for-1 kick on that because of the way it deposited and how the actuarial stuff works. We really got about $45 million of benefit out of that $25,000 deposit. And but anyway, we continue to monitor that UI fund and because it does affect every employer in the state. And but I just thought I would share that because 250 was peanuts compared to the $500 million of benefits that went out to Wyoming residents and workers. That concludes the presentation on the section 300, Mr. Chairman.
Thank you for that good information on section 399, Senator Perkins. Questions on section 399? Section 399 is closed, and we do have a final section 400, Senator Perkins, and it says this act is effective immediately upon passage, I believe. I'm going to ask if there are any questions on section 400. Section 400 is closed. Are you ready for the question on Senate File 1? All in favor of Senate File 1, passing committee of the whole, please say aye.
Aye.
Any opposed, no. Senate File 1 has passed committee of the whole. Mr. President. Mr. Majority Floor Leader, as the president makes his way up, I believe the idea is to call on you.
Mr. Chairman, I move that the committee of a whole rise and report with respect to the action taken to committee of whole on budget bill, Senate File 0001.
You've heard the motion. All in favor, say aye.
Aye.
Any opposed, no. That motion passes. Now, Mr. President.
You know, you'll get this down by the end of next year. It'll roll off your tongue. You've been preparing for this, like you've been doing. It's like you sing, it's like you.
See what I got. I look forward to it.
Reading clerk will read today's action of the committee of the whole.
Mr. President, with respect to the budget bill, Senate File 1, the Committee of the Whole heard explanations as follows. Section 49 closed, Section 51 closed, Section 53 closed, Section 57 closed, Section 60 closed, Section 63 closed, Section 66 closed, Section 67 closed, Section 69 closed, Section 70 closed, Section 77 closed, Section 80 closed, Section 81 closed, Section 85 closed, Section 90 closed, Section 96 closed, Section 98 closed, Section 101 closed, Section 103 closed, Section 120 closed, Section 121 closed, Section 122 closed, Section 123 closed, Section 126 closed, Section 127 closed, Section 128 closed, Section 129 closed, Section 130 closed, Section 131 closed, Section 132 closed, Section 133 closed, Section 134 closed, Section 135 closed, Section 136 closed, Section 137 closed, Section 138 closed, Section 139 closed, Section 140 closed, Section 142 closed, Section 143 closed, Section 151 closed. Section 157 closed, Section 160 closed. Section 205 closed, Section 206 closed, Section 211 closed, Section 220 closed, Section 300 closed, Section 303 closed, Section 308 closed, Section 311 closed, Section 314 closed, Section 320 closed, Section 339 closed, Section 399 closed, Section 400 closed. With respect to the budget bill, Senate File 1, the Committee of the Whole took action as follows. Senate File 1 do pass. Senator Landon, Chairman.
Senator Landon.
Mr. President, I move adoption of the committee of the whole report with respect to Senate File 1.
You've heard the motion. All in favor, say aye. Aye. Those opposed, no. Motion carried and the report has been adopted. Mr. Majority Floor Leader.
I move that the Senate resolve itself into committee of the whole.
You've heard the motion. You want to take a little break, Mr. Majority Floor Leader?
Stand at ease to the sound of the gavel.
Okay, let's, before we step back into the committee of the whole, let's take a little break, stand at ease till the sound of the gavel. Thank you.
A couple. Been trying to get rid of, like 500 to 1,000.
Yeah, filters are really friend. But the last thing would be funny. If, I don't know, we would change the effective date on that 145 to January 1st, 2023. It's how I kind of like the bill about this, that apparently people think it's got to affect the one race.
Yeah, it's, I got a. We get what it is.
Because it's what.
And this is the same. This is a single issue. So I'm in favor.
Okay, yeah, I think, and I also like the concept personally. I think it's good. But yeah, frankly, I don't think it's not even close to ready. We're gonna screw a lot of stuff up. We pass it. That'd be just about a good solution to tell all the folks that actually fuck off and still do.
Donald Trump Jr.
God, I was wondering why it wasn't that many emails compared to
Why?
other things. So yeah, I kinda
Well,
asked-
no, more. Not to bother.
yeah. Covers the Saratoga where the bicycle plant. Yeah, so apparently I was the only one that's clueless. And I was the first one. So that's the way it goes.
No, Drew like that.
Yeah, Drew likes all things with you, right?
I'll put him down as co-sponsor so he gets more emails.
Yeah.
Yeah, I recall a motion in there. It was almost formal. We're going to call it formal to bring us back into committee of the whole. So with that, all those in favor say aye. Those opposed, nay. Senator Landon. Come forth. We'll see if we can gather up our missing in action.
And these are in. Committee of the whole will please come to order. The first bill for our consideration is Senate File 101.
Senate File 101, pen registers and trap and trace devices authorization, sponsored by Senator Nethercutt, an act relating to criminal procedure, was referred to committee number 1, which returned to committee recommendation that it do pass. Ayes Senators Cooper, French, Kolb, Cost, and Nethercutt. Senator Nethercutt, Chairman.
Question.
You have heard the reading of the bill, and wow, Senator, good job. What is your pleasure, Senator Nethercutt?
Chairman, I move that when the committee of the whole rises to report, it do so with the due pass recommendation of Senate File 101. Good senators, to explain this little bill, I call on myself. Senators, this is a tool for our criminal justice agencies in the state that allows them to access what are called PIN registers and trap and trace devices. And I want you to say that 3 times fast because it's kind of fun. What is a trap and trace device? Calm down, it's not that exciting. It's been around for decades and decades. And what it does is it allows for the phone company to identify which phone numbers are calling which phone numbers. Let me underscore something very clearly. It does not reveal content of any kind of communication. End of story. So it can't hear the phone call. It can't see the text message, none of that. It just sees phone number to phone number. And we currently authorize this in our laws for drug crimes. And so we tell law enforcement that you can use this investigative tool to investigate drug-related crimes. And through your local county attorney, the law enforcement agency has to go through the local attorney, demonstrate that they have probable cause, and then get authorization from a judge to get this type of information. And so what we're doing is we're expanding it from just drug crimes to felonies and really violent crimes. And so that is what the bill does. I think that is appropriate and the right policy statement that we prioritize human life over drug investigations. And that's really the purpose. And I've heard that there is a continuing need as it relates to this technology. Again, it is not invasive like other types of warrants that would obtain type of technological data that we have discussed before or that you're aware of. It really is just this simple, which phone is contacting which phone. And that's all it reveals. And again, it has to go through an attorney and then the judge, and there has to be that probable cause threshold. So with that, I would stand for questions.
Questions, committee? Senator Scott.
Mr. Chairman, could this device potentially be used by the homeowner, the person that owns the phone, to get law enforcement to try to find out who's trying to perpetrate particular kinds of scams? If there enough money involved so that potentially you're dealing with a felony. And am I right in saying that that is currently outside the scope of this bill, but would be an expansion to it?
Any other questions before we go to the good senator? Senator Nethercutt.
Thank you, Mr. Chairman. The bill does not limit the type of crime for the use of the investigative tool. So if law enforcement found that it would be, information would be revealed to where there's probable cause that a crime has occurred, and that this device would be helpful in understanding that, I think that they would. So the answer is yes. I think it's also important to recognize the level of work that goes into getting this particular information. And so there's kind of that natural prohibition for it being used excessively. And also it doesn't reveal, contents of communication. So it's a limited investigative tool as well. So long as the crime is a felony, so long as law enforcement is interested enough to investigate, so long as an attorney approves it, and so long as the judge does as well, would that information be utilized.
Thank you, Senator. Any further questions on Senate File 101? Are you ready for the question? Senator Case.
Mr. Chairman, thank you very much. I'd just like a little bit more discussion. How come these were involved in the first place? Why were they used, just as I understand, for drug crimes? Is it probable cause seems to be the standard? By the same standard, could someone go to a judge, could a prosecutor, law enforcement go to a judge and say get a warrant to actually intercept telephone message or intercept, so why do we actually need this when you could actually listen to the calls? So what's different? Is this just easier and faster and reveals the connections? So what's different? And we've had it for a long time. So why does it change now? And why is there any kind of advantage? And what about civil liberties?
Senator Nethercott.
Thank you, Mr. Chairman. You're talking about a T3 warrant, which is the interception of phone calls. Really, really, really rare. Judges hate them. So do attorneys, because they're so invasive. Recognizing that Fourth Amendment right to privacy, unwanted and unreasonable searches and seizures. So for the ability for law enforcement to get what's called, to tap your phone. What are those crime shows that you see where law enforcement is tapping your phone? And that's really organized crime, very sophisticated criminal enterprises where that type of warrant is issued. And so the review level is very stringent associated with that level of invasion into someone's privacy. So they're very rare. This is this obviously, as indicated, does not go into the contents of the conversation, just which device to which device. Why now? How did this origin begin? It began when Wyoming was experiencing and the country was experiencing the drug trade in the 70s, which was when we stood up our state law enforcement agency and gave them special investigatory powers in order for them to facilitate the investigation of drug crimes and drug transactions in the state. And so obviously when you're able to see which drug dealer is communicating with their customers, it's fairly easy to understand where that conspiracy can lie. Law enforcement has wanted the ability to use this particular investigative tool for other types of crimes, but recognizing the resistance associated with that, let it go and did what they could for other pieces. But they would like to do that now. They would like to be able to apply that to felonies and particularly violent crimes, to recognize that this is an investigative tool. And it just seems silly that we would authorize it for drug crimes, but not for homicides or other types of serious felonies that would justify this type of an investigative tool. So that's why now, I think it should have happened a long time ago, but I know that there has been, appropriate discretion and caution associated with that.
Follow-ups or additional questions, Senator Case?
Mr. Chairman, I agree. Civil liberties sort of seem kind of silly to me too, those silly little things. And Mr. Chairman, so basically why we're doing this is because they're easier to get. So we can get them easily, so we can apply them to more people. You can't really go the whole deal and get a warrant to actually listen to people's conversations or read those text messages. But you can get something that says, hey, contact was made with these telephone numbers. And so now law enforcement has to go to those other telephone numbers and try to put it all together. I don't blame them for wanting to try to do that. But what we're really doing here is we're making this tool more available because it's easier to get it from a judge than a real, that if you have a serious crime and you need a warrant and you want to really reveal the conversations, you would go and do that. So we found an easy tool to use. So let's expand, because judges are easily persuaded to apply this in the drug situation. Let's keep it easy, and so we can apply it to more people in more situations, Mr. Chairman. Are you following me? Rather than going the hard route, proving your case, getting a warrant, and protecting civil liberties. So, and I also find it really strange that we have a standard of protecting civil liberties. So we found a tool that maybe we misuse now, and maybe it's too easy to get. So let's expand that, because we need that somehow. Thank you, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. I have a couple of questions. I imagine circumstances which are on the extreme side of the crime of violence, and we've got a definition for that here. And I think they conjure up the need for immediacy and I think diligent, effective response. The concern I have, though, is that while that's what's conjured for the need, when you read through the crime of violence definition here, and you kind of contemplate the low end of applicability, it means any offense that has an element, the use, attempted use, or threatened use of physical force against the person or property of another. So now contemplate, instead of use of physical force, which sounds like a crime of violence, the threatened use of force against property as being what's effectively the low end. And is that something that was intended and that we're comfortable with? Because at that point, it's relatively nebulous. You don't have a clear and direct action. It's not against a person, it's against property. And it almost seems like there's not enough urgency or immediacy that you would want to potentially take the additional steps that would infringe on privacy rights, whether justified or not. We know that they're innocent until proven guilty. And at that point, we have to be thoughtful about how far we want to go. And then the next, so I'm curious about the discussion with the low end of it. When we have a circumstance where you have somebody who's kidnapped and is threatening to hurt somebody, obviously we're talking about an entirely different scenario and much easier to support. And then when you look at the specific clear language, so on 73803A, where we're adding new language of applicability for use of the pen, register, or trace device, we have or when relevant, the old conditions which are specific to drug crimes, and it does, I agree, definitely seems odd that you could do this apparently for a small amount of drugs, but not for the violent crimes that we think of in the extreme circumstance. But again, the language that's here is or when relevant to assist in the apprehension of a person for whom there is probable cause for that person's arrest for a felony or a crime of violence. We've got an or clause, Mr. Chairman, that basically indicates that we don't even have to have the implied violence. We just have a felony and there's probable cause for the felony. So does this language not open it up to really any charge, particularly to the extent that a lot of times we'll have a felony charge outstanding, even if it's pled down to a misdemeanor? They typically will start with felony charges, even if that doesn't end up being realized. So I'm asking for a little more discussion on where the line should be drawn for the use of this and whether this might be a little on the open side, since I think it applies to nearly every investigation of a felony, whether that's a violent felony or not. Thank you.
Senator McKeown.
Thank you, Mr. Chairman. The thing that's alarming me about this bill is we now have different standards for probable cause. Probable cause for a T3 is very hard, but if we think it's a minor crime, it's easy. But isn't probable cause probable cause? If we can prove probable cause to get the pen, we should be able to prove probable cause to listen to the conversation. I think we're trying to find easy way out and skirting the Fourth Amendment. Thank you, Mr. Chairman.
Senator Nethercott.
I object, Mr. Chairman. I believe the testimony has misstated facts and evidence throughout. The good senator from Albany County hit what I hope to be the policy question for the body, which is, for what types of crimes do we want to give permission to law enforcement to use this necessary, approved in all 50 states and territories, investigative tool for at least 50, 60 years, no less than, since the time of the invention of the telephone, and what crimes we don't. And so truly what I believe is appropriate is expanding it from just drug crimes to serious felonies. And I think there's a good question where an amendment would be welcome from the senator from Albany County, potentially Fremont County, probably not, to eliminate the threat of property crimes. I would say it was discussed and thought about, and a legitimate question arose, did this go too far? Maybe, and that's a policy question for the body. Some of those crimes that I think are relevant, it would be a useful tool for those common sense crimes associated with a serial burglar that is very difficult to catch or capture and is part of a sophisticated burglar ring, you know, of people stealing tools and copper in the community. And those sometimes are very hard to capture. And this is an investigative tool for those purposes. And you know, so policy question for the body to consider, but I do think at a minimum, it is an appropriate policy statement for this body to say, law enforcement, you have the ability to use this investigative tool that's been around since the advent of the telephone, subject to the Fourth Amendment of the United States and state constitution, to investigate serious felonies. I think that's appropriate in addition to marijuana. So just something for the body to consider. And law enforcement investigates crimes, and there's plenty of it, as we know. I mean, is there an allegation that the folks in the prison are innocent? They committed crimes, and that required law enforcement to use investigative tools to begin the process, to understand there was a victim, to understand that there are people involved, that there is harm to our communities, trying to give them legal tools in the toolbox to investigate those crimes. That's what we're trying to do here.
Further questions? Are you ready for the question? All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report it, do so with a recommendation that Senate File 101 do pass, please say aye. Aye. Any opposed? No. Senate File 101 has passed committee of the whole. The next Senate file for our consideration is Senate File 36. Would the reading clerk please read the bill?
Senate File 36, for-profit public benefit corporation, sponsored by the Blockchain Committee, an act relating to corporations, was referred to committee number 7, which returned to committee recommendation that it do pass amended. Ayes Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, chairman.
You've heard the motion. What is your pleasure, Senator Driscoll?
Thank you, Mr. Chairman. I move that when the committee of whole rise to report it, do so with favorable recommendation on Senate file.
36.
36.
Senate File 36,
And
Senator.
for further explanation, I call on Senator Rothfuss.
Senator Rothfuss, would you like to have the standing committee amendment read in at this time? So we're going to go to Senator Nethercott.
Mr. Chairman, I would like that standing committee amendment read in if I could, please.
Senate File 36, Standing Committee Amendment number 1, page 6, line 4, after.
Okay, Senator Nethercott.
Thank you, Mr. Chairman. Good senators. You love for-profit public benefit corporations. Let me stress the word for-profit, creating entrepreneurism in our state and business development, but for public benefits. How could this go wrong or be bad? I hear your overwhelming support in the room. So as this bill came out of the blockchain committee over the interim in the summer, and we heard that there was the need for a creation of a new type of business entity in our state that is really a for-profit public benefit, because what we're used to hearing about is nonprofits, right, that have that designation and for a charitable purpose. And so this is kind of altering that in a pretty significant way, that you can have that charitable purpose or a public benefit purpose, but still be for profit. And so what the bill does is it lays out, based on the Wyoming Business Corporations Act, the requirements for formation of a corporation, very similar to what we see in Title 17 already. Some particular designations that might be important to you, unique to this type of entity, is on page 5, lines 13 through 18. So a nonprofit, non-stock corporations. A nonprofit corporation shall not be a constituent corporation to any merger or consolidation with a for-profit public benefit corporation. So making sure, I think this is an appropriate protective measure, that there is not confusion between the nonprofit community and the for-profit benefit, and that one cannot present to be what it is not. You may not care as much about that provision. There's the duties of the directors that go through. Periodic statements and third-party certification. Again, here are those sidebars. As we're familiar with, those nonprofit entities receive, special exempt status as a result of their charitable purposes. But when we see here on page 8, here is that third-party certification that for-profit entity is actually acting as a public benefit. Requirements to meetings of stockholders, annually provide information to the stockholders, pretty kind of standard stuff associated with business entities. Enforcement of balancing requirements, going on to page 10. This requires different duties associated with the directors of the corporation to understand how they're balancing their public benefit purpose as opposed to just revenue generation with a for-profit understanding. So typically in a private corporation, your primary mission and your duty to your shareholders is to increase revenue, increase profits. This discusses the balancing requirements associated with that. Mr. Chairman, I would move the standing committee amendment number 1 to Senate File 36 and ask for your favorable consideration. Because senators, on page 6, line 4, we have this amendment that says, after chapter, insert, and that the directors of the for-profit public benefit corporation are required to balance the pecuniary interests of the stockholders and the public benefits identified in the corporation's articles of incorporation. So again, going back to balancing the interest of the shareholders and balancing the public benefit purpose, that's a requirement that the directors are required to do. With that, I'd stand for questions on the amendment and ask for your consideration.
Senators, we are on the standing committee amendment number 1 to Senate File 36. Questions on the standing committee amendment? Comments? All in favor of the motion by Senator Nethercott to pass standing committee amendment number 1 to Senate File 36, please say aye. Any opposed, no. The standing committee amendment has passed. We're back on the bill. Senator Nethercott.
Vote aye, good senators. It's a good opportunity for Wyoming.
Are you ready for the question? Senate File 36. All in favor of Senator Driscoll's motion that when the committee of the whole rises to report, to do so with a due pass recommendation on Senate File 36, please say aye. Any opposed, no. Senate File 36 is passed committee of the whole. The next Senate file for our consideration is Senate File 102. Would the reading clerk please read the bill?
Senate File 102, Unclaimed Cooperative Utility Deposits and Payments, an act relating to cooperative utilities, sponsored by Senator Driscoll, was referred to committee number 7, which returned a committee recommendation that it do pass amended. I, Senators Boner, Driscoll, Nethercott, and Scott. No, Senator Case. Senator Driscoll, Chairman.
You've heard the reading of the bill. Senator Driscoll, what is your pleasure?
Thank you, Mr. Chairman. I move that when the committee of a whole rises to report it, do so with a favorable reading on Senate File 102, unclaimed cooperative utility deposits payment. It has amendments. Could I have the amendment, first amendment read in, please?
Would the reading clerk please read in the standing committee amendment?
Senate File 102, Standing Committee Amendment number 1, page 2, line 8, after.
Senator Driscoll, would you like the committee of the whole amendment read in now, or do you want to work that in a little bit later?
I've got to move this amendment first, please. I'd move for standing committee amendment number 1 to Senate File 102 and ask for your favorable consideration. Go back to the bill. Folks, this is a great little bill that was actually brought to me by the cooperatives. What we have out there is lots of cooperative deposits that have been through the years given for cooperative hookups, some of them from, or a big part of them, from companies either gone bankrupt or have gone away. And what this bill does is allows the cooperatives to have those deposits rather than sitting for their life in unclaimed property, not getting claimed, and most of them will not. Allows them to go back into the cooperative and feed back into the benefit of the cooperative. And our cooperatives in Wyoming are nonprofits owned by their members. So I'll go back and go through the bill just a little bit with you. The meat of the bill is Little Romanet C, and it says notwithstanding Wyoming statute 3424-109, any other provision of the law, any deposit or advance payment been refunded, included the interest thereon, has not been claimed by the member appearing on the records of the cooperative for more than 2 years, shall be determined to be unclaimed, notwithstanding any other provision of law, including provisions pertaining to the unclaimed property. Unclaimed refunds for the deposits or advanced deposits shall be used by the cooperative utility for the benefit of the membership. It goes on down, subject to a subdivision that goes back to some of the unclaimed property. And then we go back, shall not apply to deposit or advance payments made to a cooperative utility subject to provisions of the Wyoming Cooperative Utilities Act. I'll go back to the amendment on it here. The amendment moves into that just a little bit. So the amendment that we're on comes back in on page 2, line 8, and it says after cooperative serves, and if subsequently claimed may be refunded or not refunded at the discretion of the cooperative. And so what that actually says is, even though the 2-year deal, it runs back, if you've got a member that comes back 8 years later and said, my grandmother had money here and somehow it got mothballed away, the cooperative, if it's forbidden to give it back to them, they can still do it. And I think for all you out there that know your local cooperatives, they're going to give any refunds back they're legitimately due. I can say that with a good heart. I've worked with mine all my life. The real long and short of it is a lot of these aren't very big in a lot of co-ops, but it happens to be up in our area of the woods. We happen to have a gas boom years ago that paid a lot of the state's bills for a long time. And so happens when that boom ended, it did so quite abruptly. And it left literally many millions of dollars, more than one, that's sitting in unclaimed property. And our cooperatives suffered some really bad hardships from these bankruptcies. Nobody showed up to take them, and we'd really like to see those funds to go back to that end of it. So with that, I'd stand for questions on the amendment.
We're on the standing committee amendment number 1 to Senate File 102. Any questions? Senator Hicks.
Yeah, Mr. Chairman, on the amendment, I'm just wondering if the cooperatives are going to give the money back, if somebody comes back past the 24 months, why do we need to leave it at their discretion? If they're going to give it back anyway. I don't see either they're going to give it back or they're not going to give it back. And I just don't understand why we need the language is at the discretion of the cooperative. So just why we need that language would be helpful.
Okay, any other questions before I go back to Senator Driscoll? Senator Case.
Mr. Chairman, thank you very much. I kind of think this puts it in perspective of how we handle deposits and other things throughout the rest of business and commerce in Wyoming. We have something called the Unclaimed Property Division, and there's an unclaimed property law. What happens is if you're, say you have a bank account, you forgot about the bank account, it went dormant. Eventually, the bank tries to contact you. If they're unsuccessful, they can turn that bank account over to the Unclaimed Property Division. Unclaimed Property Division takes the financial assets. They're invested by the State Treasurer's Office. It's part of the State Treasurer's Office. And we get the return off of that, meaning this people of the state of Wyoming. It's a good thing for banks because the last thing a bank wants, for example, is to have an account that's got $27 in it and they have to carry it on the books and send out statements or whatever that get returned. So it's a good thing for them. It's a good thing. It's a pretty good thing for the person whose account it is, because no matter how many years go by, you can always get your money back if you learn that it is yours. And so that's why we have publications, there's a website, and it goes on. So it's always been the same practice, whether it's a profit, nonprofit, what have you. The unclaimed property provides a remedy, whereas the asset is removed from the entity that's causing the headache, usually because it's small, but it's not always small. The state of Wyoming becomes a caretaker and acts in the interest of the person and tries to find the person. But if they don't find the person, they invest the money, and we, are the beneficiaries, the people of Wyoming. It's a little bit more complicated for physical property, contents of safety deposit boxes, all these sort of things. But there's no distinction made. Some banks are co-ops. Credit unions, basically a co-op. Other businesses, there are other types of utilities that are nonprofit utilities. They have deposits. Other entities have deposits. You might belong to a farmer's co-op, and that's where you buy your gas and maybe some of your supplies. There may be a deposit situation there. I don't know. But I fail to understand why we're doing this. And in none of the cases, unclaimed property keeps. You can come in 10 years. And yes, the state of Wyoming has enjoyed earning money off your asset, but you can get your money back, the principal anyway. Here it says, well, if you're doing business with a co-op, 2 years, you may or may not get it back. And the state of Wyoming unclaimed property doesn't have anything to do with that. Why are we singling out this type of activity? There are lots of other nonprofits, lots of other for-profits. Is this the beginning of unwinding and letting everybody just keep the money? Now, how hard do you really think that people will want to turn things over to the Unclaimed Property Division if eventually they can establish a policy that they can just keep it? I don't care if you're a profit or nonprofit. There's a bad incentive there. So the amendment drives right into that. It actually says, hey, it's legal to just take the money, and you get to decide. I find that a little insane. Thank you, Mr. Chairman.
Thank you, Senator. Senator Scott.
Mr. Chairman, there was a question asked as to why we have that provision in there for the cooperative to have some discretion. The fear was that if you didn't have a provision, you'd be precluding them with this act, Mr. Chairman, from somebody was 3 years or 4 years out, small operation, and the cooperative wanted as a business matter to be able to accommodate their customer and give the deposit back. If it's a much larger one, the purpose of the bill is to enable these credits that are being unused to basically be used for additional capital for the cooperative, where that is a problem. In order to be able to accommodate the customer, who really ought to get the money back, you got to give them discretion. So if some big outside corporation comes back, or maybe didn't have, but some big one that would really, they've used the money to invest in more lines or whatever, it's gone. You would really preclude the whole purpose of the bill if they could then be forced to return these bigger ones, where it would make a big dent. You couldn't deal with it statistically, where it'd make a big dent in the ability of the cooperative to function. So that discretion language is important in preserving the objective of the bill here.
Senator Driscoll.
Fellow senators, I don't think it's insanity for members of a co-op to hope that their money goes back to the co-op rather than the state of Wyoming to generate interest for them. We already do this, folks, with the same cooperatives. We do it with capital credits. It's in the law right now. We allow the capital credits. If they can't find the owners, they go back to the co-op. That's the way it is now. This is a similar type situation, and it really is unique. I look through this room and I see many of you that have either are served or have been served by these rural cooperatives, and they truly are. They're our friends and our neighbors. And that's who built them. They put power in the 1950s to our homes, and they took care of us. And we take it really seriously. I've been a member of my local farmers co-op that does gas. I have no problem with it, those deposits to go back. They're usually little, they're not a big deal. These co-ops are, some of these deposits that are out there, they're big. Like I said, I'm going to talk a little about mine at home. They got stuck with millions of dollars of debt on these bankruptcies that we paid out of our co-op. These were outfits that came in, they made a lot of money from Wyoming. But they hurt our co-op. When it left, they hurt it. They left them with some damages. And, interestingly enough, they left some deposits back there hanging, and we'd really like to see those go back. And I truly think those of you that are served, and I hope you think about it when you vote, would you rather have your money hanging out at the state for a while, maybe forever? Or would you like it to go back and benefit what your granddad and your dad put a lot of toil in to put power into these rural areas? And I think it's logical that we go ahead and make this exemption. I think we'll fend off the insanity of other suggestions of that type to come, because they truly are different beasts. I stand in support of the amendment. If it happens to be a six-figure one, the co-op may say, sorry, we really can't afford it. It hurts our members. But for these other ones, I think they're going to go out and say, if it's grandpa's one, you're going to get it back. So I encourage your aye vote on the amendment, please.
Are you ready for the question on the standing committee amendment? All those in favor of Senator Driscoll's motion to adopt the standing committee amendment number 1 to Senate File 102, please say aye.
Aye.
Any opposed, no? The standing committee amendment has passed the committee, and Senator Driscoll, we do have a committee of the whole amendment.
Mr. Chairman, I would move committee of the whole amendment number 1 and ask for Senator Nethercott to give the explanation.
Senator Nethercott.
Thank you, Mr. Chairman. Senators, I'd ask you to vote no. There'll be another amendment forthcoming to address some of the concerns from the stakeholders discussed. So I'll ask you to vote no.
Okay, you've been asked to vote no. All those in favor of Senator Driscoll's motion to adopt committee of the whole amendment number 1 to Senate File 102, please say aye. All those opposed say no. No. That committee has failed. We are back on the bill. Senator Griff. Question having been called, all those in favor of Senator Driscoll's motion that when the committee of the whole rises to report to do so with a due pass recommendation on Senate File 102, please say aye. Any opposed? No. Senate File 102 has passed committee of the whole. The next Senate file for our consideration is Senate File 62. Would the reading clerk please read in the Senate file?
Senate File 62, extending sunset date for the Office of Consumer Advocate, sponsored by the Management Audit Committee, an act relating to the Office of the Consumer Advocate. Was referred to Committee Number 7, which returned to committee recommendation that it do pass amended. Ayes Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Driscoll?
Mr. Chairman, I move with the committee of the whole rise to report it, do so with a favorable action on Senate File 102. And for further explanation, I got to look at the bill.
Senator Driscoll, we're on Senate File 62.
I'm sorry.
Okay.
Let me look it up. Who had it, Tara? Go ahead. I call on Senator Nethercott.
That motion
Sorry,
was
Mr.
on
Chairman.
Senate File 62 committee, and we'll go to Senator Nethercott.
Thank you, Mr. Chairman. Senate File 62 is extending the sunset date for the Office of the Consumer Advocate. Good senators, there is a standing committee amendment, if I can have that read in.
Would the reading clerk please read in standing committee amendment number 1?
Senate File 62, Standing Committee Amendment Number 1, page 1 above line 1, in.
Senator Driscoll, excuse me, Senator Nethercott.
Thank you, Mr. Chairman. Good senators, this bill is about the Office of the Consumer Advocate. Since it was started a few decades ago, it has been under great scrutiny and challenge, and there's always a sunset provision associated with its continuance. The Corporations Committee was asked to review that sunset provision again, and we determined that it was time to repeal that sunset division as a result of the continued asks on that agency, particularly in light of our changing energy development and utility consumption. We have passed legislation out of this body already this session, really putting a great burden on them in navigating the needs of consumers with net metering and other types of issues. The Office of Consumer Advocates is a very important office that requires high-level expertise associated with utility regulation and rate making. They deal with the public, they advocate on behalf of the public, they interface with the Public Service Commission, and they interface with with our large utility companies and electric producers. They've been a valuable resource to the committee and to the public. And so we also need to attract the right kind of talent that we have historically seen and want to see that continue. And I think that's difficult to do when the office could be eliminated with a sunset provision. And so the amendment repeals the extension of the sunset provision and eliminates it altogether. So if you look at that amendment, it simply results in the Office of Consumer Advocates remaining in perpetuity until this body decides to eliminate it, which it certainly can at any time. But it's not going to be on the chopping block with this sunset provision every so often. That is the amendment. And so I would move Standing Committee Amendment number 1 to Senate File 62 and ask for your favorable consideration.
Thank you, Senator Nethercott. Questions on the Standing Committee Amendment? Are you ready for the question? All those in favor of Senator Driscoll's motion to adopt Standing Committee Amendment number 1 to Senate File 62, please say aye. Any opposed, no. The Standing Committee Amendment has passed. We are back on the bill. Senator Nethercott.
Thank you, Mr. Chairman. You heard the testimony or you heard the information on the bill. I'd ask for your favorable consideration on the bill.
Are you ready for the question on Senate File 62? All those in favor of Senator Driscoll's motion that when the committee of the whole rises to report to do so with a due pass recommendation on Senate File 62, please say aye. Aye. Any opposed, no. Senate File 62 has passed committee of the whole. Senator Rothfuss.
Next bill for your consideration is Senate File 106. Will the reading clerk please read the Senate file?
Senate File 106, Transportation Statutory Amendments 1, sponsored by Senator Landon. An act relating to highways and transportations was referred to committee number 8, which returned a committee recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Landon.
Thank you, Mr. Chairman. I would move that when the committee of the whole rises to report it, do so with a due pass recommendation on Senate File 106. Mr. Chairman, Senate File 106 is a return of some information that you may recollect. This was part of an omnibus transportation bill that you might remember from a couple of weeks ago, which I believe rightfully was sent to the grave. But there were a couple of provisions in that bill that I thought were very much worth our consideration. This one, quite simply, Mr. Chairman, is an update and really updates our statutes. The statute in question on page 2 allows the department to collect a $30 fee for replacing specialty plates if they are lost, mutilated, or destroyed. And it has not been updated, Mr. Chairman, since 2009. And in the meantime, since that time, we have added street rods and custom vehicles and special plates like the Gold Star plate. We have added tribal license plates, and we've also added wildlife conservation plates. So all of those plates are the statutory references that you see in the middle of that page. We have been busy with our license plates, Mr. Chairman. And so this bill simply seeks to pull them up to date and into our statutes. There is also information, Mr. Chairman, having to do with license stickers. This is a registration and plates bill. I'll specifically take you over to page 4 and run you quickly down through what we are up to there. The issue is that Chapter 16 addresses antique vehicles and dealerships. Dealer licensing was redefined way back in 2005, allowing all dealers to sell these antique cars. And so this language update really deals with antique vehicles. And we strike some provisions and we bring up to date that language as well. I'm very happy, Mr. Chairman, to drill down deeper. I've got information on each one of these statutes, but basically, fellow senators, this is a cleanup to our transportation statutes, and I hope you'll support the bill. Be glad to answer any questions if you want to go deeper. Thanks.
Thank you, Senator Landon. Let's see if anyone would like to hear the riveting details. And I see that the good senator from Turner County, Senator Scott.
Mr. Chairman, one very simple question and then maybe fan the answer or comment. Does the plates that they're going to be allowed to charge a fee to replace, do those include the prestige plates that have something special that somebody wants in terms of language on it? I remember at one time my brother had a plate that was County 1 and that said 2 Bar on it, which was the name of the ranch, that sort of thing. Does it include replacing those kind of plates, Mr. Chairman?
Thank you, Senator Scott. Any additional questions before the sponsor rises again? Any additional questions? Seeing none. Senator Landon.
Mr. Chairman, that's a good question to my friend from Bates Creek. It doesn't change anything with these fees. It does reference our fee structure in the one area. And we had fees in 2 different statutes. And so we eliminate those fees in one, reference the other statute. That way, if we ever increase the fees at some point down the road, it will all be done in the one statute. It doesn't raise any fees for the department, doesn't change any registration fees. It does change the recreational vehicle statute a little bit on page 4 and allowing for somebody to pick up 2 of those instead of 1 if they wish. They can pay for a second one. So that is in reference to recreational vehicle shows and out-of-state folks wanting to bring their recreational vehicles into our state. And that's the tweak on that language. But nothing really changes in this. So thank you, Mr. Chairman.
Thank you, Senator. Back to you, Senator Scott.
Mr. Chairman, what I'm trying to get at is are these, the plates that you're talking about, do they include these prestige plates or do they not?
Thank you, Senator Scott, for that clarification. Are there any further questions for the good chairman as he's looking for the answer to the question? All right, seeing none, Senator Landon.
Mr. Chairman, my apologies. I guess, and I apologize to the senator. I'm not understanding the question, I guess. I'm not getting there. What we change in this bill, we pull street rods and custom vehicles and that list of additional plates that we have adopted through the years. We're pulling those into the statutes, which allows for us to collect that $30 fee. We just reference the statutes where those fees are. I'm not quite sure, Mr. Chairman. I'll get with the good senator. If this goes through committee of the whole, I'm just not sure what licenses the good senator might be referencing. My apologies.
Thank you, Senator. One more try, Senator Scott.
Well, Mr. Chairman, I was concerned about the prestige plates, whether they were on this list or not. And let me share with the Senate the history here. We had quite a debate one time. We had Mr. Chairman, a citizen in Natrona County who had his first name on his plate. And the plate disappeared while it was parked on a street in Laramie. I think he was down there for a sporting event or something, and his plate just plain disappeared. And he was trying to get the department to reissue it, and there was a problem about it. And that's what the legislation was about. And Mr. Chairman, he had his first name on it, and where he thought the plate probably wound up was on the wall of some sorority house in Laramie, and his first name was Dick.
Thank you, Senator Scott. All right, Senator Landon, what are your thoughts?
Well, Mr. Chairman, the senator in front of me volunteered to go find that plate. I'll tell you that.
Good
You
to
know,
hear. Thank you, Senator.
The answer is no, Mr. Chairman. I'm 98% sure that we're not talking about those plates in this bill, but I'll be glad to do some research and get back to all of you. And appreciate the senator. I'll get back to him on that, Mr. Chairman. Thank you.
Thank you, Senator Landon. Any further discussion? We're on Senate File 106, Transportation Statutory Amendments 1. Further discussion? Seeing none, questions been called. All those in favor of Senator Landon's motion that when the Committee of the Whole rises to report it, do so with the do pass recommendation on Senate File 106, please say aye. It was enthusiastic. Let's hear the no's. No. None. Senate File 106 has passed the Committee of the Whole. The next bill for your consideration is Senate File 117. Will the reading clerk please read the Senate file?
Senate File 117, Speech and Hearing Specialist Licensing Amendments, sponsored by Senator Pappas, an act relating to professions and occupations. It was referred to Committee Number 10, which returned to committee recommendation that it do pass. I, Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen, Senator Baldwin, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Baldwin?
Thank you, Mr. Chairman. I move, excuse me. I move when the committee of the whole rises to report it, do so with the recommendation that Senate File 117 do pass. For explanation of the bill, I refer to a former Labor and Health Committee member, Senator Pappas.
Senator Pappas.
Thank you, Mr. Chairman. I bring to you a real quick little bill that's a cleanup for some legislation that we passed last time. If you recall, we had a bill that created an interstate compact for speech language pathology and audiology. In that bill that created that compact, it also removed all of the folks that were certified under PTSB from PTSB's certification process and moved it to the State Board of Speech Language Pathology and Audiology. Unbeknownst to me and certainly the director of PTSB at the time and apparently a couple directors before them, there were a few people that got caught in this that we did not know that did not have the credentials to be licensed by the state board. Our statutes say that in order to be a speech language pathologist, you have to have a master's degree. Well, apparently sometime way in the past, there were some folks that were certified and licensed with a bachelor's degree. So when we removed that, them from the PTSB, they went to seek certification with the state board, and they couldn't do that. It was not our intent to legislate people out of a job. So basically, if you look at the bill, we're adding a new paragraph in there, 33-105, eligibility for licensing. A person who held a valid certificate as a speech or hearing specialist issued by the Professional Teaching Standards Board and was employed by the school district to deliver speech language pathology or audiology services on or before July 1st, 2020. That's when the law that switched them went into effect, shall be qualified and eligible for licensing by the board as a speech language pathologist or audiologist, notwithstanding the requirements imposed under the paragraphs Romanet 1 through Romanet 3 of that section. So basically, they don't have to comply with what a current applicant would need. So if they had a job with PTSB and they were either with the school department, as it goes on, you'll see says any person licensed under this subsection shall only be authorized to practice as a speech language pathologist or audiologist in the public school system or in a program for the developmentally disabled funded by the Department of Health. Those were the two types of people that the PTSB took care of. So if they were previously licensed, we're going to let them continue to do their job because they've been doing it for years. There's not very many of them, and they cannot go out and do private practice or practice in hospitals or in any other speech pathology, and certainly they can't practice under the state compact when that comes about. So cleanup bill, trying to help these folks stay employed. Thank you, and I'll stand for questions. Thank you.
Thank you, Senator. Any questions on Senate File 117? Are you ready for the question? All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report it, do so with a favorable recommendation on Senate File 117, please say aye.
Aye.
Any opposed, no. Senate File 117 has passed committee of the whole. The next Senate file for our consideration is Senate File 107. Would the reading clerk please read Senate File 107?
Senate File 107, Transportation Statutory Amendments 2, an act relating to highways and transportation, sponsored by Senator Landon, was referred to committee number 8, which returned to committee recommendation that it do pass. I, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman.
You've heard the reading of the bill. What's your pleasure, Senator Pappas?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, you do so with a recommendation that Senate File 107, Transportation Statutory Amendments number 2, do pass. And for explanation of this bill, I'm going to call on my shadow back here. Right here. The good senator from Madrona County, right? Is it a surprise to him, Mr. Chair?
You know, maybe it was. He's got that, he's got a nice little sheet of talking points, but maybe the senator needs a chance to find those or.
I don't know. Mr. Chairman, I don't know the talking points on this bill.
We, Senator Pappas, we can either lay this back, or do you remember the conversation in committee about this bill? If not, let's just lay this bill back for a day.
Mr. Chairman, I could dig out my notes, but I would need to take a moment.
Okay, absent objection. Pardon? We'll just lay it back a day. Absent objection, we'll just lay this back one day. Senate File 107 has been laid back. We'll consider that one tomorrow. The next bill for our consideration. Thank you, Senator Driscoll. Barring objection, Senate File 107 will be laid back for one day. The next Senate file for our consideration is Senate File 96. Would the reading clerk please read in the Senate file?
Senate File 96, Homicide Amendment, sponsored by Senators Hutchings, an act relating to crimes and offenses. It was referred to Committee Number 1, which returned to committee recommendation that it do pass. Aye, Senators French, Kolb, Cost, Nethercott. No, Senator Cooper. Senator Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Nethercott?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with a do pass recommendation on Senate File 96. To explain this bill, I call on Senator Hutchings. There is a committee of the whole amendment, if I can have that read in.
Senate File 96, Senate File 96, Committee of the Whole Amendment Number 1, page 1, line 3, after.
Senator Rothfuss. Oh, point of order, Senator Case. My apologies.
I'm wondering how we got this practice of trying to move the committee of the whole amendments, which are sponsored by a single person or more. At the time the bill is discussed, when it's certainly appropriate to move standing committee amendments, which are sponsored by the committee. And so we often do that to tangle them together. But when did we start having the bill begin with the discussion of a committee of the whole amendment, which is brought by an individual member? In this case, the bill sponsor, but I think it's inappropriate. I think we should try to avoid this practice.
Thank you, Senator.
Mr. Chairman, if I may.
Senator Nethercott.
Thank you. My apologies. I just was trying to help the process and the explanation of the bill and make sure that that amendment was read in on that bill. So I did not move that amendment. So the good senator will need to move the amendment that was not done. It simply was read in. My apologies, Mr. Chairman.
Thank you, Senator Nethercott. No apology necessary. I knew what you were up to, and that was a very good point made by the senator back in the corner as well. As the floor manager goes through the bill, I will try to help remember that we do need to work that committee of the whole amendment. But Senator Hutchings.
Thank you, Mr. Chairman. And I too took no offense and appreciate all the help I can get from my Laramie County colleague. Senate File 96 is a wonderful bill. I spoke to our nationally certified coroners, DAs, and prosecutors around the state and got their input on this bill to create a very good bill. This bill is about murder, Mr. Chairman, in the first and second degree. According to the CDC, murder is the #1 cause of death in pregnant women. Currently, 3 members of the 66 have been affected by this crime. There are several instances of this crime here in Wyoming. The current sentencing enhancement in Wyoming Statute 6-2-109 is not adequate. This bill will repeal it and provide an adequate crime and penalty. In 2004, our federal government passed this legislation. For over 35 years, 38 states from coast to coast have enacted this law. This bill creates a dual homicide charge for killing a pregnant woman. I'll go to the bill. An act relating to crimes and offenses, creating new offenses for first and second degree murder. On page 1, line 12, we start with definitions and go on to page 2. As used in this act, unless otherwise defined, unborn child means a child in utero. Child in utero means a member of the species Homo sapien at any state of development who is carried in the womb. This particular definition is in our federal laws. And when I was talking to our DAs, this is the definition that they thought would be best for our laws, as it would help them best defend this type of crime. We have first degree murder, a penalty. A person is guilty of murder in the first degree of an unborn child if the person kills or attempts to kill any human being under any of the circumstances specified in subsection A of this section. We go to page 3. We have murder in the second degree and a penalty for that. Except as provided in Wyoming statute 6-2-109, which we're repealing, whoever purposely and maliciously, but without premeditation, kills any human being is guilty of murder in the second degree. And we have a penalty of 20 years for that. The unborn, I think that's pretty much covers the bill. The amendment, Mr. Chairman, which I wanted to move for the committee.
So Senator Hutchings, sorry to interrupt, but you know
ahead.
what I'm going to ask? I want to make sure that we had read in the corrected copy.
That's what I was.
Committee of the
gonna talk to you
Whole
about.
Amendment number 1 to Senate File 96. And just to make sure we have that
I
covered
don't
with
think
the
we do.
reading clerk, please read in the corrected copy.
Senate File 96, Committee of the Whole Amendment Number 1, corrected copy, page 1, line 3, after.
Okay, now we're sure that we're on the correct Committee of the Whole Amendment. And would you like to move that, Senator Hutchings?
I'd like to move it, Mr. Chairman, but I don't have it. I think the
Does
one.
somebody
I-
close by have the amendment by any chance, the corrected copy that they could share with the senator?
I was gonna, thank you so much.
Thank you. We've got it covered. Thank you, Madam Clerk.
Thank you, ma'am.
The Chief Clerk
Appreciate
is Johnny
that.
on the spot as usual. No problem. Senator Hutchings, back to you.
Thank
The-
you
the
very
committee
much,
has been-
Mr.
the
Chairman.
Amendment has been moved and it's all yours.
I move the Committee of the Whole Amendment number 1 to Senate File 96 and ask for your favorable consideration. What we're doing here, Mr. Chairman, is we're repealing a law that's already on our statutes. And they changed the amendment on me. So this is the first time I'm getting this to really go through it. The repealer will delete 6-2-109, and it's kind of lengthy, but all it's doing is removing any mention of it throughout our statutes. So what that would do would repeal, I'll give you the verbiage on it so you kind of know what we're doing here. That will repeal a sentencing enhancement for homicide of a pregnant woman causing the involuntary termination of her pregnancy. So, Mr. Chairman, with that, we can vote on the amendment and then talk about the bill.
Questions on the Committee of the Whole Amendment number 1, Senator Case.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd like to bring out whether this amendment is germane to this bill and whether it's clearly indicated in the title. In the description of the bill, it was mentioned that the bill had a repealer. But when you look at the bill, it does not have a repealer. And the title says, an act relating to crimes and offenses, creating new offenses for first and second degree murder, providing definitions and providing for an effective date. Doesn't say anything about repealing existing law in the same area. And where we get in trouble with this, Mr. Chairman, is if this bill, for example, were to repeal that statute that exists now, but yet the language of this bill did not survive a court challenge, then we may be left without tools in our law to persecute and enhance the penalty for murder in the case where a woman is pregnant. It's dangerous ground, and I think it violates the Constitution to have where it says that all bills shall be clearly indicated in the title what they do, Mr. Chairman. And this one would go into the title, expand it, and take an existing law that's been on the books for a long time and repeal that. That wasn't the way the bill was brought. This is a fix at the end, and I suggest to you that it is not clearly indicated in the title, and it is an unconstitutional attachment. Thank you, Mr. President, or Mr. Chair.
Further comments, Senator Nethercott.
Thank you, Mr. Chairman. Good senators, I'd ask that you vote no on the amendment. I do think that we have been too generous in this bill. And the striking of the mandatory 40-year minimum needs to be in the bill. And so rather than repealing that statutory section, I think we probably should bring a second reading amendment to add it back in to be consistent with our sentencing guidelines.
Further comments, further debate. Senator Guru.
Just a comment, Mr. Chairman, this bill's a lot of things, but generous isn't one of them. And I do ask you to defeat the amendment.
Are you ready for question? Senator Rothfuss.
Thanks, Mr. Chairman. Point of order. I would ask for a ruling from the chair on the germaneness of this amendment pursuant to the fact that we have a suggestion as provided by the senator from Fremont County that this is outside the original intent of the legislation as determined by the title.
The chair rules that it is not germane.
Thank you, Mr. Chairman.
Senator Hutchings, back to you on the bill, and just for future reference, this will go on through another reading if it passes committee of the whole, and the chairman of Judiciary has indicated that maybe an amendment could come at that time. So we're back on the bill. Senator Hutchings.
Thank you, Mr. Chairman. It's kind of sad because that's what I wanted to do, was to defeat the amendment that was out there because I didn't get a chance to read the corrected copy and go through it. So I would like to withdraw the amendment, Mr. Chairman.
Senator Hutchings, thank you. Without objection, that amendment has been withdrawn.
Thank you, sir.
And we are back on the bill. Further debate? Questions for the good senator? Comments? Senator Scott.
Mr. Chairman, I'm having a little difficulty understanding all the implications of this bill. Mr. Chairman, as I read it, there's a definition here that would cover any embryo, fertilized egg, anything like that. Frankly, the definition is in conflict with what my church believes. And then if somebody destroys it, you can wind up with a first-degree murder charge. Is this a bill to, frankly, label anybody that performs an abortion somebody that's guilty of a murder? What am I saying things that go bump in the night here? Or you get a doctor that performs one of these that results in the death of a fetus and did it to protect the life of the mother, we're gonna make him a murderer. Is that what's going on in this bill, or am I totally misreading this?
Senator Perkins.
Thank you. And I'm gonna try and answer it because this is from the perspective of somebody who just saw the bill today. So it's not from perspective of someone who I do that. But I think that what you have to do is you start off in the bills it is, Mr. Chairman, and you've got in D, a person is guilty of murder. This is on page 2 of the bill, starting line 15. A person is guilty of murder in the first degree of an unborn child if, and then there's a 2-pronged test. The person kills or attempts to kill any human being, actually 3-pronged test, but human being under circumstances specified in subsection A. So we'll go back and talk about subsection A. So that's the first thing. It has to be killed under, and we'll talk about, and what is subsection A says, whoever purposely and with premeditated malice are in the perpetration of or attempt to perpetrate any sexual assault, sexual abuse of a minor, arson, robbery, burglary, escape, resisting arrest, kidnapping, or abuse of a child under the age of 16, kills any human being is guilty of murder in the first degree. So you've got to have that the killing of the human being has to be under those circumstances. So that's test 1. Test 2, the second prong of that test is the human being was pregnant with a child. So you have to have killed, as I understand it, and if I'm wrong, the proponents can correct me. So the first element is you have to have killed the pregnant mother. And then the third, under those conditions that we just were specified in A. And the third one is that the unborn child within the pregnant mother dies as a result of that. So you have to have, really at this point, you have to have the precondition is the pregnant woman has to have died and the child has to have died. And it has to have been with purposely and premeditated malice. So even if we were talking, I would think even if you're talking about a legal abortion, I think that you can't meet the malice. You can't meet the malice provisions of that. And then the rest of those are basically felony murder situations in the commission of another crime. So maybe but that's the way I read it at first glance today.
Senator Scott.
Mr. Chairman, that's, thank you. That's a very useful explanation. So this is really what it is an enhanced penalty for killing someone who's pregnant, where you destroy and does it, we had a bill before that we debated at length, and I think passed, didn't we? Where there was a simply enhanced penalty, and the testimony from we had committee from the then police chief of Cheyenne was that they did see these where the woman was killed because she was pregnant, and it was by a former boyfriend that probably responsible for the pregnancy or was mad about it. And that was a crime that they did see, and it was a particularly heinous kind of crime, and we agreed with that. If that's a very different bill, and if that's what this is doing, then what we're really doing is just making that a more of an enhanced penalty. Is that a correct understanding of what's going on in the bill?
Senator Perkins.
And the answer is, I don't think so. I think this is a twofer. I think this is a twofer, and that there's, and maybe I'm reading it wrong, but and that I guess that's the question I have in this. At the end of the day, I look at this and you have the pregnant woman dies as a result of that, and then 2 is the unborn child dies. And so I'm trying in my mind, I don't have a clear distinction here. It seemed to me that if you do both those things, I don't know why there's not 2 murders, but yet it doesn't necessarily specify that there's 2 murders in the bill. And so maybe I don't, and so this is the question I have, which gets to the point as I read the bill. The question I have is the murder of the mother, the pregnant woman, is that punishable just under 62101A, which is the one we read? That's just the death of that person. And then this only punishes, this is a second murder for the human being that was pregnant with the child, but the reference is back to human beings. So I'm trying to figure out, seems to me like this is a kind of unique situation where 2 people have to die and you get charged with 2 murders, or you get charged with 1 murder. I'm not sure. And if it's 2 murders, then that's not a penalty enhancement, it's 2 murders. If it's some kind of twofer and it's only 1 crime that's being committed, which this seems to maybe do, then I'm not sure what this bill does as far as penalty, other than it's first degree murder, but is it 1 or is it 2? And how do we do that? And it's not clear to me how that works. It doesn't mean we can't fix this, but to me, it's not obvious.
Senator Nethercott.
Thank you, Mr. Chairman. The mother does not have to die. That's the major distinction, where there's a gap in the law right now in the criminal code. And this is the reason for the bill from the good senator, is that, and I'm going to use an extreme example for purposes of illustrating the point. Bad guy shoots pregnant woman in the stomach with a shotgun and she lives. But the 8-month baby is killed. What is the crime in that scenario under our current statutes? There's no acknowledgement of that life. That might be 8 months, 9 months along. And certainly we can go give the extreme of embryos and all of those pieces, I know, but let's also start from the other back end, because recognize we have prosecutors with discretion and pieces all along. They also have to prove it. So it's that case where she's clearly pregnant, far enough along, she gets killed, or she is attempted to be killed, but survives it, and the baby is killed. And so there's nothing really in our law that addresses that. Of course, the crime would be attempted homicide for her, or potentially aggravated assault, but there is no acknowledgement of that life. Now, under our code, if she was killed, certainly the charge would be homicide. And then there's that sentencing enhancement, which is certainly significant and important, that we discussed, which was just tried to be repealed in the amendment, which does acknowledge in our criminal code the significance of taking the life of a pregnant woman and the recognition that someone who is guilty of that crime should serve a very serious sentence with that mandatory 40-year requirement. But this is different and does fill that gap for the law. And again, we can talk about all of the scenarios associated with she's 2 weeks pregnant and should he know or should he not know. And again, there's plenty of crimes that require, I know we don't like them, but prosecutors to use discretion. And I think this would be one of those cases where it was very clear and the conduct was very egregious. And there's still an acknowledgement that with the intent to kill, you kill the baby. And that should be punished accordingly as a homicide. And that's what the bill does.
Are you ready for the question on Senate File 96? Senator Rothfuss.
Thank you, Mr. Chairman. I'm curious if there was discussion, though, on narrowing it so that you did have to have intent and knowledge, and again, just setting up circumstances of parallel construction. We definitely have a very different standard with regard to accidental homicide, for example, unintentional. And you could imagine a circumstance where you have an attempted murder circumstance and an unintentional associated accident, which we'll say ends in the loss of life. I'm not sure how that would come out in statute, but again, it would not be 2 murders that you would be looking at considering, or 1 attempted murder and 1 murder. If you have an unintentional, and would that end up being manslaughter at that point in time if you don't know it's happening? And this is a question perhaps for the chair of the Judiciary Committee. How would that work out if you set up a parallel construct? And what would the charges be? And then the second question is, again, I know that there are variations on how much we want to place the confidence in the prosecutor in this chamber. But if we didn't want to, and if we wanted clarity of when this should and shouldn't apply, are there other states or other statutes that have been drafted elsewhere that provide a greater level of clarity and direction to provide that clearer delineation, where again, previous statute had intent and knowledge. And I'm curious if other statutes are available that have that. And then the final question I have just is a drafting question where I honestly don't understand why we have a definition of unborn child, which means a child in utero. And then that's immediately followed by a child in utero with then a definition. The mathematician in me suggests that we just do a substitution and carry it through with one term. So is there a reason why we have both terms defined, where one is just defined into the other and then the other is used throughout? Just for Occam's razor, would it be expedient to pick a term? Thank you, Mr. Chairman.
Thank you, Senator. Any other questions for the sponsor or the chairman? Senator Hutchings.
Thank you, Mr. Chairman. Great debate. And I would like to say thank you to Senator from the President of the Joint Appropriations Committee for helping clarify parts of the bill, and the Judiciary Chair for coming to my rescue as well, and filling in where there were some additional questions. This will create a dual homicide. And I said it from the very beginning. This deals with first and second degree murder. And those are clearly defined. Since we are going to be working on amendments on second reading, I call for the question, Mr. Chairman. Thank you.
Senator Perkins.
Thank you, Mr. Chairman. As I think about this, I just a couple other things that that strike me as you do this and try and figure out how this works. So if you go in and this kind of predicate is subsection A of 62101, and again, you go through that, it's purposely premeditated malice. You kill someone, or in the perpetration of or attempt to perpetrate any sexual assault, sexual abuse of a minor, arson, robbery, burglary, escape, resisting arrest, kidnapping, or abuse of a child under the age of 16. So, I'm trying to think about how this works and in certain cases, and just seeing if there's a hole there. And I note that A does not include any kind of aggravated assault, is not a predicate felony charge. And the reason I bring that up is what if the human being who is pregnant with an unborn child is in on the murder or attempted murder of the unborn child? And so I guess you could say it's premeditated malice, but the intent was not necessarily kill her or that she's in on it. So and keep in mind, you cannot consent to an illegal act. So it's the consent, it's not about consent, because that doesn't apply in this situation. But I mean, at the end, there's I think you're at the worst, you're looking at an aggravated assault or something like that, but yet it's not going to be murder because that is not listed as one of the felony murder crimes in the first sentence. I'm just wondering if there's a hole there that you may want to look at and plug, and keep in mind that if you do that affects felony murder in every other instance. And I'm not a criminal lawyer. It's been a long time since I did criminal law in law school, but anyway, and maybe there's an answer to that question, but it's just something that kind of seeing how this works, I'm struggling with exactly how it would. Thank you, Mr. Chairman.
Thank you, Senator. Senator Hutchings.
Thank you, Mr. Chairman. I'm assuming the good senator was talking about page 3, line 7. I wasn't really clear on where he was indicating his question.
Further debate, further questions. Are you ready for the question?
It's on page
All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report it, do so with a due pass recommendation on Senate File 96, please say aye.
Aye.
Any opposed, no. Senate File 96 has passed committee of the whole. The next bill for our consideration is Senate File 110. Will the reading clerk please read in the Senate file?
Senate File 110, Small Claims Procedures, sponsored by Senator Nethercott. An act relating to small claims procedures was referred to committee number 1, which returned to committee recommendation that it do pass. I, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Nethercott?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with a favorable recommendation of this good little bill, Senate File 110. Small claims procedures, much lighter and smaller bill. Good senators, what this bill does is corrects what I think is an error that existed in statute regarding how to serve a defendant in a small claims action. Currently, the law as written precludes the ability to serve a defendant outside of the county where where the action arose. So for example, if I went over to Albany County and committed some type of civil wrongs where someone wanted to sue me for $5,000, but I, as a resident of Laramie County, they couldn't serve me until I went over the mountain and they knew when I would be in Albany County and they could catch me. And that seems silly, which is the word of the session. And so this bill attempts to eliminate that county requirement and expand it to state. I have shared this bill with those that preside over the small claims court, and they recognize the challenge and appreciate these corrections. So stand for questions.
Questions? All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report it, do so with a due pass recommendation on Senate File 110, please say aye. Aye. Any opposed, no. Senate File 110 is passed committee of the whole. The next Senate file for our consideration is Senate File 157. Would the reading clerk please read in the file?
Senate File 157, Property Rights Limitation on Local Authorities, sponsored by Senator Beitman, an act relating to cities, towns, and counties. It was referred to committee number 5, which returned to committee recommendation that it do pass amended. Ayes, Senators Boner, Bouchard, French, Cost, and Wasserberger. Senator Boner, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Boner?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do with a favorable recommendation on Senate File 157. There is a standing committee amendment. I ask that it be read in at this time.
Senate File 157, Standing Committee Amendment number 1, page 1, line 1, after.
Okay, Senator Boner.
I move standing committee amendment number 1 to Senate File 157. And for an explanation of both the bill and the standing committee amendment, I refer to the prime sponsor.
Senator Beitman.
Thank you, Mr. Chairman. Got another good little bill for you here, fellow senators. Senate File, I offer Senate File 157, possibly the most pro-property rights bill of the session. Certainly is one of the simplest bills. 5 logical lines to add important clarity and to corral what this body will see as a new angle to government overreach. Primary purpose of this bill is to prohibit cities and towns from conditioning the provision of public improvements on the inclusion of restrictions on property valuations. Yes, we as the legislature give municipalities wide latitude and broad authority with regard to typical water and sewer connections. Utility-based latitude on pipe size, infrastructure specs, process and development alternatives to handling water and sewer, utility-based latitude. Social agendas are not utility-based latitude. We do not give towns and cities the latitude and authority to use the publicly paid for water and sewer system to control the price of the house, who can live there, how much homeowners can earn, and what the resale price is. That is not utility-based latitude. That is social engineering. And that is not authority this legislature gave. You and I both know we never gave that authority. Senators, this abuse of authority means that towns can devalue private property by withholding water and sewer system capacity from free market unrestricted homes. So to the bill. Those famous 5 lines I talked about, you'll see on page 2. This is within the water and sewer section of the municipal water sewer section of state statute 157101. We're going to add subsection B, notwithstanding any provision of this title, no city or town shall condition the provision of any public improvement under subsection A of this section on the inclusion of deed restrictions or other restrictions which limit the value of property or properties. Everything else down below is dealt with in the standing committee amendment. And I will explain the standing committee amendment. Simply deletes lines 7 through 21, everything on the rest of the bill that deals with county commissioners. That's not applicable to this bill. And with that, Mr. Chairman, I will call the question or entertain questions on the standing committee amendment. And I
Thank
ask
you.
for your favorable consideration.
Thanks, Senator Beitman. Questions on the standing committee amendment? All those in favor of Senator Boner's motion on standing committee amendment number 1 to Senate File 157, please say aye.
Aye.
Any opposed? No. The standing committee amendment number 1 to Senate File 157 has passed, and we are back on the bill. Senator Beitman.
Thank you, Mr. Chairman. There's also a committee of the whole amendment. I'm not sure if you all have seen that yet. It's up on the website.
Let's,
May I ask-
Senator Beitman, let's have that read in
I was
real
gonna
quickly.
say, let's read
Okay?
that in.
Thank you.
Senate File 157, Committee of the Whole Amendment Number 1, page 2, line 5, after.
Would you like to move that now?
I would like to
Senator?
move that, Mr. Chairman,
Okay, thank you.
and I'll explain it. It just adds a little bit more clarity for the cities and towns, what the true intent of this bill is. It's not to really get in there and micromanage. You'll see on page 2, line 5, after properties, we're going to insert, nothing herein shall contravene the discretion of the cities and towns to deny connection to the municipal sewerage system for utility-related reasons. So there's the difference. And it also makes it effective immediately, Mr. Chairman. It's important to make sure that this gets done right away to protect private property rights. Pretty self-explanatory, and I'll stand for any questions on the committee of the whole amendment, Mr. Chairman.
Questions? Senator Scott.
Mr. Chairman, I neither have a text of the amendment nor could I understand the speaker. So, Mr. Chairman, I would respectfully request that he repeat his remarks on behalf of the deaf lobby a little clearer so we can understand what's going on.
Senator Scott, I absolutely resemble that and understand, and I know that the good senator will be willing to go back over that amendment again, and the microphone police just called in and said, hey, lean up there and give Senator Scott another shot at it. Senator Beitman.
Thank you, Mr. Chairman. I'll try to not mumble. I know my wife yells at me all the time about that. So yes, the the committee of the whole amendment number 1, what it does on page 2, line 5, after the word properties, we're going to insert the language, nothing herein shall contravene the discretion of cities and towns to deny connection to the municipal sewerage system for the utility-based reasons. So that prevents, that just goes right with the spirit of the bill here. What this bill does is to make it so they can't include deed restrictions and other restrictions which limit the value on properties. I'm adding this language to clarify the intent of the bill. And also, Mr. Chairman, changing the effective date on page 3 from July 1st to effective immediately. That is what the committee of the whole amendment number 1 does.
Okay, we are on committee of the whole amendment number 1 to Senate File 157. Senator Guru.
Thank you, Mr. Chairman. Just a question on the committee of the whole amendment. Could the bringer of the bill please explain utility-based reasons and just give me an example, please? Thank you.
Senator Perkins.
And, quite frankly, maybe it's late and it's been a busy week so far for appropriations, but can can you read to me, somebody read to me what lines 1 through 5 as amended in the bill are going to say now? Because actually, I was looking at the amendments and we were going through them pretty fast, and it looked to me like most of the bill got deleted. And so if somebody could read to me the whole sentence on the operative language, so I at least have some continuity of exactly what it says now, because I'm not clear.
So Senator Rothfuss.
Thank you, Mr. Chairman. Actually, I'll wait until that's answered. My apologies. I think that's good to get that answered, and then I'll stand.
I'm going to go to the chairman of the committee, and Senator Boner, would you be willing to help us with where we stand on the bill? Thank you.
Yeah, thank you, Mr. Chairman. And this was a discussion we had in the Senate committee. And it's real, I mean, simple. The bill is basically those first 5 lines on page 2. That's the bill now in its entirety. And we're just adding the language that you see, the new language on the amendment to the bottom of that paragraph. So it's pretty straightforward. And the idea that we have is we want to make sure that there's no unintended consequences. For example, I live in I don't know what you call it. It's a little subdivision, a little area outside of Douglas, for example. They tried to have this little community all be self-sufficient on their own wells. That didn't work. It's real close to town. The city had to run a utility line out to that subdivision to make it work. And so the intent is we don't want to somehow prohibit things that may be necessary for a municipality to ensure that their utilities work properly if they're adding on new developments onto their existing system. So we're just trying to make sure that obviously this bill, make sure it works moving forward, make sure there's no unintended consequences. And so that's the idea behind the committee of the whole amendment. I appreciate the sponsor bringing it forward, because we don't want to limit the ability of municipality to have some sort of restrictions on private property that are required for the functioning of the utility that they're in question.
Senator Boner, I believe the way you described, just to help the good senator in the back of the room, the first 5 lines of page 2 still exist. And what the committee of the whole amendment would do after the fact that the standing committee amendment deleted the rest of that is that it would add to paragraph B. Is that correct, Senator Boner?
Yes, Mr. Chairman. So that single sentence you have at the top of page 2 is the bill, and we would add another sentence in the amendment to the end of that sentence.
Okay, thank you for catching us up. Further comments, debate, Senator Cole.
Thank you, Mr. Chairman. Just a general question about this bill and what it's trying to do. I think I get the general idea, but I think the question is, or maybe you can answer this, do the cities have the right to zone as they please or not? I think, we all have, I guess, opinions about what municipalities do, or for that matter, even in the counties, although this doesn't address that. But is this some way of telling the cities that they cannot do with a zoning process to restrict some sort of building or, I know they do it to the municipalities when they hook up to the utilities. That's apparently what's being indicated here. But how is it going to be relevant to the cities and their zoning ability in the future, say, if they say this got enacted with this kind of language? Will it stop them on making any decision? Or is it just one particular kind of decision we're trying to work on here? I'm concerned that maybe some of these things are too broad. I think I will support this through this process, committee of the whole, but I certainly would like to know more about the consequences for this to cities with their zoning ability. Thank you, Mr. Chairman.
Senator Perkins.
And thank you, Mr. Chairman. And just to put a finer point on my good friend from the Sweetwater Country point, so you get back and you got, and I guess it gets back to the ability to zone. And just a little background for members of the body. So you've got a zone, you've got something zoned, and you come in and you want to build a structure, you want, and so you're going to need taps to the water and other utilities, so water and sewer and whatever else. And so you've got a zone, and then in your zone, typically you've got a whole long list of things that you can do that are permitted uses, and I don't think that's a problem, but then there's a whole nother laundry list of things that are conditional uses. And when you have conditional uses, then you say, all right, you can, even though it's zoned this way, these are conditional uses, and you can use it, you can build that structure or do whatever it is you're going to do with that property and use it. But here's some conditions that we're going to put on your use of this property so that it complies with the neighborhood and the other issues that go on as you try and zone. And so those are conditions, and this says restrictions. And I get deed restrictions. Zoning is not deed restrictions, but it says other restrictions. It says or other restrictions. And so it seems, if this is supposed to be a rifle shot to deal with that and avoid an abuse of the zoning situation, it would seem to me with this expansive language that we may be missing the mark and using way too big of a weapon to deal with this. But maybe I'm off on this, but I mean, those are restrictions that are used all the time. Some of you have counties that don't have land use plans, and some of you do. And so complying with these land use plans is a big deal. And to some degree, if the statement of the legislature is simply, you can't put any restriction on here that affects the value of your property, I can tell you that many of the restrictions and conditions that are put on these conditional use permits or variances or other uses that people want to do with property, I mean, that's how you structure your community. And if that's what this bill does, I don't think that's the intent, but but that seems to me what it does. And if I'm wrong on that, I would love to be corrected and steered in the right direction. Thank you, Mr. Chairman.
Senator Bateman.
Thank you, Mr. Chairman. Due to short-term memory loss, I felt the need to get up and answer some of these questions before they get away from me. So there's a few of them out there. To start with the first one about what are we talking about with regard to utility-based latitude? What I have in mind there and what this bill contemplates is basically just pipe size, infrastructure, capacity, real technical things. And remember, ladies and gentlemen, we are in 15.7.101, which is the municipal water sewer section of the state statutes. We're not in the zoning. And to answer the good former president's comment or question, you can't use the water system and utility system to zone. And that's what we're getting at here. That's the crux of the issue. So this is very narrowly tailored in that specific section of the law. We're not changing zoning. We're just saying you can't use water hookups and sewer hookups to zone, to put deed restrictions, to mandate certain types of housing on your private property, to mandate how you're going to use that property, to basically put a condition on your property, say, yeah, we'll let you hook up, but you got to do this, this, and this. And it really limits your private property rights. That's what this bill is all about. So remember, you cannot use this sewer statute to zone, and this is what the bill does. Thank you, sir.
Senator Perkins.
So, I appreciate that, and I agree you shouldn't use it to zone, but the other side of that, and looking for unintended consequences, let's just give you an example. Let's say that we've got this zoned to single residential family homes. And so you have, it would be obviously to be denied a tap to a sewer or water would be outrageous because that's a permitted use. It's obviously use there. But if you come in and you want 15 taps, or you want 15 taps or water sewer, because ultimately your intent is to have a multi-use plan there, I'm struggling with how that would work. And it seemed to me that this basically says, I'm sorry, you can't do that because that affects the value of my property. So it's not directly zoning, but it seems to me that does this bill, when we have other restrictions, does this tip the scale too far in the other direction? And do we need to just slim this down and focus this a little bit more? Thank you, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. Chairman. I'd ask that this amendment be divided into the two clean divisions that are apparent. Division 1 being the first paragraph, line 5, is it 5 or 6? Line 6. Division 2 being lines 7 through 11. And if you find that divisible, I'll chat about Division 1.
Senator, that is divisible.
Seemed like it.
Yeah, pretty easy, actually. I just got caught reading that second part. And it was kind of fun and catching up a little bit.
Thank you,
Okay,
Mr. Chairman.
Senator Rothfuss.
Yeah, Mr. Chairman, I'm on and for Division 1. It probably makes things better, although there clearly needs to be a little bit of a language cleanup. So I'll pause there. Thank you.
Okay, we're on Division A of the Committee of the Whole Amendment number 1 to Senate File 157. Discussion. All those in favor of Division A, please say aye.
Aye.
Any opposed? No. Division A has passed. We are on Division B of the Committee of the Whole Amendment number 1, just Senate File 157. Senator Rothfuss.
Thank you, Mr. Chairman. This is the effective immediately language, and I do have concerns about the bill that have been discussed, and we'll get back to those when we get to the bill. But I guess those concerns are exacerbated by the fact that apparently we're in a big hurry to do whatever it is that this bill does, that, to be honest, I don't understand. So can we have a little more discussion on why this has to happen as soon as it possibly can, instead of July 1st, which kind of leads me to believe we're probably trying to do something about something that's happening somewhere right now, which gets into one of the things that I'm often concerned about that the legislature does time and again, which is start trying to put our legislative authority into a local problem. So why does this have to happen as soon as we can get it done?
So we're talking about Division B, and Senator Biteman.
Thank you, Mr. Chairman. On and for Division B, for the main reason, we have a constitutional issue here at stake. This is very important. Private property rights are the foundation of this country and this state. Without private property rights, we're a whole different looking country right now. And what's happening in this very specific example, that gap in time between when this bill is signed into law and the effective date, the municipality in question could ram through something very devastating to private property rights and use that gap in time to really injure a person. And I think it's our duty to protect those rights. And we've granted these rights, we've granted broad latitude to cities and towns and counties for good reason. We like our local control, but they don't have carte blanche over your private property rights. If they are in a gross violation, it's our duty to step in and react. And we don't always have this problem, but occasionally we do, Mr. Chairman. And in these types of cases, I think it's prudent that we act. Thank you.
Division B, Senator Guru.
Thank you, Mr. Chairman. On and against. We seem to be honing in on it now. Maybe you can start to pick it up just little by little. It's coming here. It seems that, as it often happens around here, there's two reasons why bills come in the Wyoming legislature. The reason we say, and then the real reason. And if you notice here, the real reason is starting to emerge. That we're starting to hear now that there's something happening. And there's something happening that we have to stop right now. Don't know quite what it is yet. Good bringer of the bill hasn't let us in on that. But that gives me pause, and that's why I'm against this amendment, this part of this Division B, because I'm still waiting to hear what we're talking about. And I'm still waiting to try to understand. So why the big rush and what's the big hurry? So on and against, Mr. Chairman, thanks.
Further debate on Division B. Senator Rothfuss,
Just one.
bring us home.
Thank you, Mr. Chairman. So on and against Division B, speeding this up. And Mr. Chairman, if this is a constitutional issue where we have a transgression that abridges the constitutional rights of a property owner, there are courts and there are lawsuits. And I'm beginning to suspect that this was a solution that was just trying to get a more rapid remedy for somebody that is a stakeholder in one particular instance somewhere. And oddly enough, it's usually my community, but in this case, I haven't heard of it yet, so I'm guessing it must be somewhere else. But Mr. Chairman, there are judicial remedies to deal with constitutional concerns. And we haven't precluded access to the courts quite yet. So, Mr. Chairman, I don't think we should be in a hurry to get this on the books. And I think everyone should be concerned that if we feel like this has to be done immediately, that it might not be good policy if we really don't know what's going on here. And I know I still don't. So on and against, Mr. Chairman.
Okay, the question, Senator Kinski.
Mr. Chairman, I think it's important that the act be effective immediately because it is protecting a constitutional interest. And rather than July 1, there are judicial remedies, and that remedy could take effect by July 1. Question is, what year? July 1 of 2023, 2024, 2025. I mean, judicial remedies are great in theory and in the abstract, but it's not a good enough remedy when simply by exercising our legislative prerogative, which is also an avenue. I mean, you can sue or you can petition your government for the redress of grievances, and that is what is happening here. And I'm certain the sponsor of the bill will give us more detail on it if we can get past this amendment. So I would say that we keep the effective immediately, and that we get on with the substance and the merit of the bill. And if it doesn't seem to be something that needs to move with some degree of alacrity, we can always postpone it to July 1 on the second or the third reading. Thank you, Mr. Chairman.
Thank you, Senator Kinski. Regarding the motion made by Senator Beitman on the Committee of the Whole Amendment number 1 to Senate File 157, we are on Division B. All those in favor of Division B, please say aye. Aye. Those opposed, say no. No. That Division B has passed. We are back on the bill. Senator Beitman, you want to take us home on this one?
Thank you, Mr. Chairman. I think we've discussed this. I've answered all the questions I think I've been asked, and I'd be happy to just ring the dinner bell and bring this thing home unless there's other questions out there, Mr. Chairman.
Senator Beitman, thank you, but we do have other questions. Senator Kinski, and then I'll go to Senator Scott.
Thank you, Mr. Chairman. There is a situation that, as I understand it, involves a county where some folks are required to provide water and sewer if they are within a certain proximity of a city or a town. And that approval to connect is hinged on the property developer agreeing that X proportion or all of it shall be deed restricted to low-income housing. And that's a condition of the issuance of a water and sewer permit. Now, that may be a proper discussion for a zoning ordinance, but it is not a proper discussion for withholding a water or sewer permit. And the constitutional basis of it comes in. There is a US Supreme Court ruling, and I know we're not supposed to use proper names, but it is a Supreme Court case. It's known as the Malibu Beach case, where a fella had some property along the beach, and he wanted to pull building permits so that he could build some housing. And the city said, sure, we just want access through your property to the beach, and we'll be happy to give you a building permit. And he said, well, if you want an access to the beach, get your checkbook out. You either buy it or you condemn it. It's my property. And they said, you don't seem to understand. We're City Hall. Don't you read? You can't fight City Hall. Well, he fought it all the way to the US Supreme Court, and they agreed. They said, the ministerial act of just issuing or not issuing a building permit, or in this case, a sewer connection, is not a basis upon which you can deprive somebody of their property. And so they said, if you want that access, you buy it or you condemn it. Similarly here, this community, if they want affordable housing, then they should go through the zoning process or whatever it is they have to do legally to restrict the property. but they cannot play keep away with a water and sewer permit. It is unconstitutional. And so with that, the bill, we need some wordsmithing on the bill, I'll grant you. But certainly that can be achieved on the second or the third reading. But conceptually, I think we want to support what the senator is trying to do here, which is a stand for the proposition that we are not going to use simple things like building permits or water and sewer permits as a means of social engineering. Thank you, Mr. Chairman.
Feels like we're getting close. Senator Scott.
Mr. Chairman, and, but this is a general statute. And I want to know if some of the practices I've seen elsewhere will continue to be legal. For example, I've seen a city say, yes, we'll let you hook up to our water and sewer if, when it becomes possible to annex. And they were talking about an outfit that was a mile or two away from the city limits, but the city was growing that way. They said, fine, we'll be happy to have you, provided you will agree to annex to the city when that's possible, when we've grown out to where we're contiguous. Would that be prohibited or allowed under this statute? And similarly, if the city had a policy, after so many units, you have to provide some public parkland, which I know my city has done in the past. Would that be permissible as a condition? Say, we're going to expect you to annex and we're going to expect you to provide a, park with the playground for the kids is basically what it's amounted to in our community. How far is this restriction going is my question.
Senator Rothfuss.
Thank you, Mr. Chairman. I appreciate the explanation. That was helpful to understand circumstances and as well as the case law that's kind of being contemplated to provide a background. But I do have a question with regard to the case cited in the circumstances. In this situation, it seems very different to me in that this is precluding any requirements specific to this section for engaging with what are effectively city utilities. So it says that we can't require a municipality to have deed restrictions when you want to engage with the city utilities or through the public improvement. Wouldn't the city or municipality at that point basically be held hostage and always have to, without conditions, just provide attachments in a way that circumvents the zoning and planning with this in place, which seems like it might be an unintended consequence? That's sort of the first question I've got. And then the second gets, well, I'll stop there for now, actually. That's the question I've got. I still have a lot of concerns, and again, it does seem like we're trying to put in place a solution to what now turns out to be one individual local conflict, as I understand it now, and legislating top down. I would ask if the individuals that are making the rules and the decisions are duly elected by their community, or if these are not elected officials. Because once again, if they are elected officials, wouldn't an election process be another alternative to us just forcing our viewpoint on some case law into the communities where we apparently have gotten through over 100 years of statehood without needing this particular statute? Thank you, Mr. Chairman.
Senator Perkins.
Mr. Chairman, thank you. And again, I think my problem with this is when we talk about the value of the property and we're talking about limiting the value. I mean, really, I think what we're talking about is restriction on uses and avoiding this with uses. And I think that, quite frankly, I think that it's not about value, it's about use. Value is going to go up, value is going to go down, but this is about use of the property. And I think that if you focus in on that, I think you'd be much more successful. Anything you do to property can affect its value. And I don't think that's what we're talking about. We're talking about impermissibly or unreasonably restricting the use of the property. And that's, I really think that that's the problem with this bill right now.
Senator Nethercott, and then we'll go to Senator Beitman to finish us up.
Thank you, Mr. Chairman. The good senator from Natrona County is, I believe, absolutely correct. That what the bill is trying to do is prevent counties, cities, or towns from acquiring certain land to have certain uses, like affordable housing, for example. But that's not what the bill says. And so I've been perplexed this whole time about what this bill does, but the senator from Natrona County, our former president, identified what the issue is lacking there in the bill. So, the bill needs considerable work, I think, in order to provide some of those clarifications. I also don't think that the second provision addresses the concern, and it is written in a way that I think provides more problems and mischief for misuse. That, I just think a statement along the lines of no sewer tap will be unreasonably withheld, and that's it. So I do think considerable work needs to be done on the bill, and have reservations about it currently written.
Thank you, Senator. Senator Beitman, let's go. I'll go.
No, we got a couple.
I'm going to go one time to Senator Kinsky, and then we're going to wrap it up with Senator Beitman.
Point of order, Mr. Chairman. It's committee of the whole.
Senator Kinsky, you're up.
Besides,
we will keep going.
Besides, the sponsor doesn't want us to go home yet.
We will
secretly
keep going.
wishes that.
Go ahead,
Okay.
Senator Kinsky.
So again, let's go back through those. Does the bill preclude specifying the kind of uses for land? It does not. What the bill says, once it's rewritten for second or third reading, the idea is I've played by the rules. I've read the regulations. If I'm going to bring this land in, I have to bring it with some parkland. If I'm going to bring this land in, I have to conform to the zoning. I've done all that. Here I am. Can I have my sewer permit, please? Well, there's just one more thing. Here it is. We want you to do X. And you have no choice because we require you to get a sewer permit from us. So it is not through the water and the sewer authority that these sorts of things come. Governments lay out their laws, hopefully clearly, and then developers play by the rules. And then when they've done so, they get their water or sewer permit. That's how it's supposed to work. You're not supposed to keep away with building permits or water and sewer permits for yet one more, it's called a government exaction, I think, in the Malibu Beach case. So this does not preclude zoning lands. It does not preclude requiring a certain portion be parkland. And I don't know whether it's constitutional or not to just say any land adjacent to the city's got to be all low income housing. If it is, and that's in their ordinances, then that's the rule. But you can't predicate it on a water and sewer permit that you require for somebody to do anything with their land adjacent to a city. As to, is the fact that they're elected a remedy? It's not. Because whether you're elected or not, you cannot act unconstitutionally. That doesn't remedy it. If they're acting unconstitutionally, they're acting unconstitutionally. It doesn't matter whether you got an election coming or 2 or 4 years. So on and for the bill, I'd urge us to, this is all good. This is healthy debate. This is what we're supposed to do on committee of the whole. The sponsor's supposed to be able to hear and elicit all the objections and concerns so that they can then bring back something that's modified appropriately for consideration by the body. So this is exactly how the process is supposed to work. Thank you, Mr. Chairman.
Senator Guru.
Thank you, Mr. Chairman. Yes, very good discussion. And I think that we're starting to hone in on it now a little bit better, and that's good. And I appreciate the good comments from the Chair of Judiciary and the Chair of Appropriations. I think those are right, spot on point, but I'm going to close it out because I don't want to belabor this any longer. But want to misspell a conception that seems to be floating around that came from my good friend from Sharon about what is happening in certain communities and what isn't. I don't know about every other community in town, the other 99 communities or 100 communities in the great state of Wyoming, but I know one real well.
and its high representative. And I can tell you, in fact, that there has been, listen closely now, no decision made in any local municipality to stop any hookups to sewer for any conditions of any kind. So as long as we're straight on that, and then we hone in on the greater aspects of this to make this a better bill, I look forward to the discussion, and we'll be having a bit of it as we go, I can assure you. Thank you.
I'm going to go to the sponsor of the bill, but not until we have played out the committee of the whole to the content of the body. Are we done? Senator Brightman, question having been called. All those in favor of Senator Boner's motion that when the committee of the whole rises to report, it do so with a due pass recommendation on Senate File 157, please say aye. Aye. Any opposed? No.
No.
Senate File 157 has passed committee of the whole. Senator Driscoll.
Mr. Chairman, I move the committee of whole rise and report.
You've heard the motion. All in favor, say aye. Any opposed? No. By golly, that has passed. Mr. President.
Reading clerk will read the committee of the whole report.
Mr. President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 101 do pass. Senate File 36 do pass amended. Senate File 102 do pass amended. Senate File 62 do pass amended. Senate File 106 do pass. Senate File 117 do pass. Senate File 107 laid back. Senate File 96 do pass. Senate File 110 do pass. Senate File 157 do pass amended. Senators Landon and Rothfuss, Chairman.
Goes back to me and
Senator Landon.
Mr. President, I move committee of the whole report.
For the motion, all in favor, say aye.
Aye.
Those opposed, no.
No.
How about give it back?
Mr. Majority Floor Leader, that clears the desk.
Mr. President, thank you. We'll start out. Everybody bring your snacks and your no-dos tomorrow. It's gonna be a long day. I kind of promised you we wouldn't do long days, but tomorrow is one of the exceptions. Probably gonna be a long day, so be ready for it. Mr. President, I move we stand adjourned till 10 o'clock a.m. Wednesday, March 10th.
Announcements, Senator, okay, Senator Scott.
Mr. President, your committee number 4, education, will meet tomorrow morning, 8 a.m. in room W110 downstairs, and also will understand be online. Senate File 143, school finance funding model amendments, the Senate recalibration bill. Mr. President, we're going to try to finish that bill. If we can, we'll also get to Senate Joint Resolution 4, school capital construction, constitutional amendment.
Senator Nethercott.
Thank you, Mr. President. Your number 1 committee will meet tomorrow morning at 8 a.m. to hear the following 4.5 bills. Senate File 20, Public Records Personnel Files. Senate File 146, 6-person juries in civil cases. Senate File 140, Human Trafficking Minors. Senate File 156, Incest Amendments. And Senate File 128, Temporary Delegation of Parental Authority if time allows. Should be a enjoyable Wednesday morning. Thank you.
All right, let's move across the room. Senator Baldwin.
Thank you, Mr. President. Your perfect committee, Perfect 10, labor and very healthy. We'll meet at 8 a.m. in the morning in extension room 6 to hear Senate File 133, prohibiting abortifacients and chemical abortions.
Senator Boner.
Thank you, Mr. President. Your five-star committee, agriculture, will meet at 6 o'clock today, and so about 10 minutes to just in the Capitol Extension Room W2 and online to hear Senate File 135, water rights livestock on federal land.
Thank you. Further announcements? Further announcements? Senator Anderson.
Mr. President, your favorite community, minerals, will meet tomorrow at noon, 15 minutes after noon recess in W4 and online to hear one bill, Senate File 152, connection of utility services.
Any further announcements? No further announcements. You've heard the motion. All those in favor say aye. Opposed, no. Senate shall stand adjourned until 10